I'm told, my lord, charge sheet has been filed.
Yes. What is the number? CS number.
PS number 58/25. Dated 30/3/20.
So are you there on interim?
My lord.
Interim was there. Interim to extend it's with the directions. CS number 88/2010, date 33.
In this case, I am appealing for
Your interim will be extended for 15 days, and then you have
My lord, kindly make it, my lord, 20 days. My lord. So one of the petitioner wife is, my lord, he is undergoing.
20 days. Okay.
my lord. In this case, I am appealing for the informant.
Oh, you are for the informant.
But yes, sir.
Acha. You are Mr.
Yes, ma'am.
S name. Hard quit for Mr. S name. Okay, well.
Obliged.
Right. The document item number 35. The counsel for a petitioner here got some difficulty, but it is outstation counsel. So may the matter may be adjourned for the and he has requested me to pay for some date fixed date. Can it be on 7th, 8th, or 30th August? 7th August or 30th.
You are for the petitioner,
Petitioner.
And for the other side.
for the respondent.
She is from Delhi, so I am paying for a fixed date. Either maybe 7th of August.
Mr. Rajiv Agnihotri.
Not she. He's from.
You are Mr. Your
I am A.R. Tohbildar.
AR.
Tohbildar.
Heard Mr. A.R. Rockbuilder appearing on behalf of Mr. Rajiv Agnihotri. And also heard MS
TJ Sahewala.
TJ Sahewala. TJ Sahewala for the respondent. Is submitted by Mr. Rockbuilder that due to personal inconvenience. The engaged counsel, Mr. Agnihotri, is not in a position to attend the court meeting accordingly paid by each of them. Considering the request made by the counsel for the petition. Please the matter you on to 13th or either
30th August. On 7th August. Okay. 7th will be 2 earlier. Today is
7, we are not
30th.
1-3.
30th.
1-3 or 3-0.
30.
3-0. 3-0 is the hearing day. 3-0 is Saturday. It cannot be.
18th September.
No, 18th September.
And what's if any other date lordship then on hearing day?
We can give you hearing day in the month of August also. 21st of August is a Thursday. You can take this one or either in month of September.
September.
You can give the 9th of September. 9th of September.
Yeah, please, your lordship. Lordship, I beg to mention item number 28. We are the newly engaged counsel. in this matter.
28.
28.
Yes, sir. What
The
is
matter
it?
is
Not
matter-
received. Are you on
it
interim?
may, yes, Your Honor.
You are in.
The matter may be taken up on 12th, Your Honor, 12th August.
No. We are not receiving the case diary. We have to fix it. You are on interim or they are on interim? Mr. Bhatta?
No, my lord. Initially, one report was called for. Later on, case FIR registered, my lord. Then CB called for no interim.
No interim. 12th may not be possible. Maybe on 14th or maybe on say 18, 19 or whatever.
On 21st of August, 21/8, my lord.
Submit the wakalatnama and the additional affidavit during the course of the date.
Mr. P. Water, Ilane, additional PP, appearing not MS TJ Sahewala submitted that they are newly engaged in the present. Accordingly, needs some time to file their wakalat. Mr. Watercourt further submitted that CD not received. To reminder, this accordingly on 21/8. In the meantime, the newly engaged counsel may file their wakalat. But have you informed Mr. These three name of three counsel has been reflected in the cause is that Jed Alam, D. Sharma, and S. Nazdin. Is there any information? Have you?
We'll do the needful.
No, now question is that while engaging, suppose you are subsequently engaged, so it is your duty. At least minimum information should be given to the other side that they have been engaged. Because these trees' name are still appearing.
Yes.
You do need.
Obliged.
Very lordship. For listing my AB lordship. That will be on 7th lordship.
7?
7th for motion
17.
lordship.
No, we are
For
not
motion.
fixing any date on 7.
8th lordship.
8, no, it's not.
For
a-
motion lordship. The petition has a lady
No,
lordship.
we are going Arunachal. We are not in a position to fix any. There are some matters that have already been fixed. Those will be there. Maybe either on Monday at
Monday
least
lord.
11.
Then Monday lord.
Yes.
Apply.
Met my lordship, my lord, I beg to mention item number 30, my lord.
30.
30, my lord.
Yes. Are you on interim there?
In no, my lord.
Not interim. Yes, Bhattakurti are not in on interim.
On 14th,
14th?
Request, my lord.
so,
Request, my lord.
21/8, 21/8.
14 may not reach also. That
Yes, 22/8,
21 or 22.
21, 8.
21
8, yes.
Deeply obliged, my lord.
issue reminder.
May I please, Lordship? Lordship, I beg to mention one bail application for listing on tomorrow, Lordship, on medical ground, Lordship.
No tomorrow. What for he is just
He-
he's
he is-
suffering from?
Lordship,
He is suffering from?
he is suffering from, like his creatinine level is very high, Lordship. This is sign of kidney damage, Lordship. And his sugar level is also very high. Like
You
up
do
to
one
eight-
thing. We are not in a position to fix any matter tomorrow, day after tomorrow. That's the reason I'll be different. So you you approach the registry so that it can be accommodated in any court, considering your medical ground. Immediately you approach the registry. It may be listed urgent.
need to apply in registry, Lordship.
You can approach the registry because we are not in a position to fix any date for this motion, either on motion also. So you may be in registry, 2 benches are also available nowadays at this court. So it may be adjusted or accommodated in any other bench. You just immediately approach the registry. If his creatinine level is high, then that may be a matter of concern.
Yes, Lordship, very serious condition, Lordship. Admitted in Borpeta Medical College, Lordship.
Now he is in,
He is in Borpeta Medical College, Lordship.
so already he is in medical
Yes,
college.
yes.
So treatment has been provided to him.
Provided, Lordship, but he needs better treatment. He is suggested to go for a nephrologist, Lordship, and endocrinologist.
In Bokata Medical College, is there any nephrologist there?
No, Lordship, he is not getting proper treatment,
But there
Lordship.
is there any facility of this dialysis and all there? No.
Maybe, Lordship, but he is not getting proper treatment. He
Okay,
needs,
you immediately approach the registry, will met. Somehow. Somehow it may be accommodated. That's what I'm saying.
public-
May I please, Your Lordship, item number 33, the matter may be wrongly listed, Your Lordship, today. Actually, the matter was fixed for 5/9, Your Lordship. CD was called for on that day, Your Lordship.
5/9. 33 to 8. CD was called for.
Yes, Your Lordship. We are on, I am on interim, Your Lordship.
Also 5/9. Oh, yes. They are all interim, na?
Yes, Your Lordship.
33, na?
33.
33, you know, wrongly listed. Matter is wrongly listed. The registry is ever directed to registry matter on the date fixed. Oh,
Obliged.
May I please, Lordship? May I please, Lordship?
yes.
I'd like to mention one criminal appeal. In the next week, it may be fixed for hearing either on 12 or 14 of next week, Lordship. 12 or 14. This is a criminal appeal, simple appeal, Your Lordship, in acquittal case, Your Honor, enact case, Your Honor. Since last several years, it has been not listed. Criminal appeal, since the age of 19, appeal is pending. Criminal appeal.
Now, Mr. Borwa is suggesting that we cannot pick it up for hearing any column.
Actually,
It may again come to the order column, in fact.
order column, it may be listed, yes, sir.
Huh?
In order column also, it may be listed, Your Honor.
Ah.
Maybe. Oh, we have already submitted our written argument. Both the side have already submitted. Way back in the year 2023 itself.
No, if it is listed in order column, what will be what's the purpose will serve to you?
But thing is that, Your Lordship, the matter is that the other side maybe got absent also. That's why I'm seeking it for order column also, maybe listed in order column. In the next hearing may be done like that order. It's very simple,
Then you are saying it may be listed on other parties is not appearing.
not appearing, yes. Last week they did not appear.
Ah.
In the last one, in the month of May 6, probably it was listed. At that time also they did not appear. That's why in the next week, if it is given for order column
Let it be on 14th.
on 14th, yes.
May I please, your lordship? I beg to mention item 10 of today's list, my lord.
10.
10.
Hmm.
I am for respond number 2. I have taken consent of the other side, my lord.
You
Maybe-
respond number 2.
Respond
You're
number.
for the petition. So
Maybe-
what is your problem?
Maybe after 1 week.
No, why you are seeking adjournment?
Actually, my senior is not keeping up well, my lord.
Acha, who is your
MS Rajbori.
Raj Bormia?
Yes.
Same ground to it. Raj Bormia is your good name?
P. Chaudhary.
P. Chaudhary. Fale petitioner Fale P. Chaudhary, and you are MS?
Archet.
R. Chetri, appearing on behalf of Mr. Raj Bormia, ground hill ground. He is how many weeks you need? 2 weeks adjournment will do? List accordingly.
My lady, may I pray for a fixed date? The trial proceedings are going on. There is no stay.
After 2 weeks, adjournment date will be.
Any date convenient to me. After 2 weeks.
No, 2 weeks will do.
There is an interim order.
Interim was there. Interim be continued till next date of.
For withdrawal of supplementary side.
Matapsun puna na saga. You are saying
Yes,
you are for the 37th?
yes, 37. Your lordship, I want to withdraw this PLF application because charge sheet has been filed. I would like to submit the copy to this honorable court. And your lordship, along with this certified copy of charge sheet, there is also a medical report in page number 12. In page number 12, it is stated that no signs of injury is found. Further, in page number 13, the opinion from clinical and radiological examination, no signs of recent.
We are not going to hear you now.
Yeah,
This is not a case of hearing. You want to withdraw this one? That's one.
obliged, your.
So your your charge sheet number is.
That's number 98 of
Do you
2025.
have any instruction in that regard regarding the filing of the charge? No. No. Yes, number of section. FIR number has. Huh? Yeah. It is finally. No, this is good. No, charge sheet. Mr. Appreciate run it also to the Mr. Keyboard to run it PP appearing on it is submitted by Chetri that the case has already been charged by CS number 98 of 2025 dated 21/07/2020 and hence as per instructions of this client he wants to withdraw this. Okay, your matter will be disposed of on withdrawal. You need this copy?
I have.
You have provided to.
Yes, obliged, your.
May it please, your lordship. On the instruction of the petitioner, I beg to withdraw this bail
You
application.
want to withdraw this one? Otherwise, we have received the case diary here? No. CD was received here?
28.
No, it was fixed on 2018. No, sir. You are Mr.
I'm R.A. Lohkar. I'm appearing on behalf of DJ Boro.
R.A. Law.
R.A. Lohkar.
Heard Mr. R.A. Lockwood appearing on behalf of Mr. DJ Boro. And also heard Mr. P. Potter. As per instructions of this client, wants to withdraw the same, prayer is allowed.
Obliged.
Okay, your petition is disposed of on withdrawal.
Your Lordship,
Yes.
on instructions, I'd like to withdraw this present bill application.
You are Mr. Iqbal, no?
Yes, Your Lordship.
Same order. A and Iqbal. Okay, your matter will be disposed of on withdrawal.
Oblige, Your Lordship.
Yes.
No, please, Your Lordship. In this case, Lordship, regular bail application, Lordship. In this case, two FIR, Lordship. Informant lodged the FIR before Dhemaji Police, SP Dhemaji District, you know. Our Lordship, SP Dhemaji forward the FIR to the Dhemaji Sodor Police Station. Bhanikula FIR, original FIR page number 20, Lordship. May I read, Lordship? সন্মানপূৰ্বক বিনীত নিবেদন এইয়ে যে আমাৰ লগতে মুঠ 48টা গোটৰ আত্মসহায়ক গোটৰ আইডি নম্বৰ ও গোটৰ নাম ব্যৱহাৰ কৰি জালিয়াতিৰে ষ্টেট বেংক এণ্ড পঞ্জাৱ নেশ্যনেল বেংকত ভুৱা একাউণ্ট ব্যৱহাৰ কৰি লক্ষাধিক টকা আদায় অজ্ঞাতে আত্মসাৎ কৰে। গতিকে দয়ালু উক্ত বিষয়টো উচিত তদন্ত কৰি আমাক ন্যায় প্ৰদান কৰে। This is the first FIR, Lordship. And second FIR, Lordship, lost one of Bharat Gogoi, Lordship. May I read the second FIR? Page number 21, Lordship.
So these two FIRs are lodged against you only
Against me.
by two other.
No, I am not a FIR name accused, Lordship. Upon receipt of the said, may I read, Lordship?
No, you were got arrested in connection with which FIR?
FIR page, FIR informant, Lordship. Rinkumoni Hazorika, Lordship. First FIR.
Yes, Rinkumoni.
Hazorika.
No, for Rinkumoni, Hazarika, you got arrested. Why you are pointing out two FIR?
Two FIRs.
You were arrested in connection with this first FIR.
First FIR.
Second FIR.
Or in second FIR also you were forwarded or what?
Forwarded. In the informant lost the FIR in the SP Dhemaji, Lordship. SP Dhemaji forward the FIR to the Dhemaji Sodor Police Station. Upon receipt of the said Azahar, both the FIR, Dhemaji Police Station registered a case as a Dhemaji PS case number 111/2025 under section 61 clause 2, 316 clause 2, 318 clause 4, 336 clause 3, Lordship.
So both the FIRs were now amalgamated and the inquiry is conducted.
Lordship. Petitioner was
you are in custody since 25/7.
25/7.
You are also the member of both.
No, I am the member. I am working as a bank mitra. Bank mitra.
Yes.
But when you annex up the forwarding report, ground of arrest, the accused person, namely Kalpana City of Bormon, was working as a bank mitra. Her work is to bring SSG number so and so bank for loan processing, but she brought false members before the ASLRM and the bank for providing loan.
Oh.
And the rejection order also, my lord, as page 27 by the CJ Dhemaji. After perusal, there are incriminating materials, sufficient incriminating materials against the accused matter. CD may be called for.
Calling for the case diary.
Is possible, is it 25th August? That may fix.
25th of August. We're listed. 25. Oh, sorry. 25th August is the holiday. 25th August is a holiday. It's
27,
26,
maybe 26 or 27.
27.
27 also. Please, Your Lordship. Regular bail application. Petitioner as on date behind number 70 days, 17 days, Lordship. Varnicola FF, page number 13, Lordship.
Here one thing is there. One office note is available. Most probably one AB is also pending. 1766.
Yes.
Pertaining to the same accused person for
Correct.
the year only. So that has already been fixed on 22/8. So we are listing it on 22/8.
Lordship, as on date behind number 17 days, Lordship.
17.
days.
Huh.
117, Lordship. All the FIR name accused already got bail, Lordship. And co-accused also enjoyed the interim protection, Lordship. Lordship, kindly consider I am working as a driver, Lordship. Last 17 days,
We
I
don't have anything before us. How can we consider now? Now see, that's why we are saying that one note is
all
also
the
there.
or in this case, FIR name accused also get bail, Lordship.
Maybe I don't know what it was the putting of the case, how they got bail.
Lordship was also allowed a I am also the one of the petitioner of the AB number, Lordship, bail application, Lordship, 1766/25, Lordship. Was
That's
also.
why
But
that is
before
the reason
get
why
order,
one
Lordship.
note is there, in fact, office note is there. Said you are one application for AB is also pending against this present petitioner. So that's why we are listing it on
22nd, madam.
22nd, along with your other AB. AB that is your 1766. 20 হেৰি কৰক, city call কৰক, 22nd 8 আৰু list along with AB 1766 public.
I love that. By village.
Yes.
This is the non-FIR, Your Lordship. Earlier occasion, report was called for. Whether the report has come or not. In this case, I'm praying for PRS to this petitioner, Your Lordship.
The report is there, madam.
Yes.
Case has been registered, madam.
You have another case on Kasumara also, no? Earlier case, no.
No. So, in this case, I'm praying for bail to the accused petitioner.
How many
There-
petitioners?
Three petitioner. One is Hanif Ali, Shohar Ali, and Fazor Ali. So in this case, the police always charging, and thereafter the police on 24/6/2025, the police personnel called the petition number 3 over telephone to make visit the police station, and accordingly the petition number 3 appeared Kasumara police station, and police personnel showed a written azhar lodged by the present informant, and wherein, Your Lordships, it has alleged that 15/6/2025, the son of the petition number 1 went to the house of the informant and took Your Lordships away of his younger daughter with the help of the petition number 1 and 2, and thereafter his daughter was not returned back. This is the actual fact. After showing this azhar, the police personnel had pressurized to the petitioner to surrender, and if not surrendered, then he may be arrested. This is the apprehend. So, in this case,
See, we don't have the copy of the FIR, in fact. What was the allegation? As per you, you have verbally submitted all this.
yes, Lordship.
That's why we do one thing. We call for the CD, trying to give a short date along with the copy of the FIR,
Lordship,
so that
if-
your prayer for AB may be considered. That's what I'm saying.
After,
Otherwise, at present, your case has already been reported as well, your case has already been registered against you. So that is the position now
Yes.
at present. So let us call for the case diary along with your copy of the FIR,
yes.
and then it may
After-
be a case.
Filing of this case, petitioner inquired before the learned CGM Corpeta and accordingly they applied and certificates is got. I submit.
It is, if it is the certified copy is with him, my lord, it is the duty of the council to bring it on record so that we can, my lord, look into it also, my lord. Without serving us the copy of the, my lord, it is difficult to say anything on this, my lord. As the report has been called, case has been registered, my lord. And as per the High Court rules, they have to submit it on by way of affidavit if their subsequent development is there. So it cannot be produced like that way, my lord, in the court.
In the meantime, kindly
Hard
interim may be
Mr.
protected.
Delaney, counsel for the petition. Hard Mr. J. Sutia, Delaney, additional PP, appearing on said respondent. Report from Kasumara Police Station is received, whereupon it is seen that the FIR has already been registered against these three petitions. On the complaint lodged by one, Iskor Ali, ESKOR, Iskor Ali. Important. In view of this, let CDB call for along with the copy of FIR.
And in the meantime, I will file additional affidavit.
List the matter accordingly. In the meantime, the petitioner is able to file copy of the FIR, certified copy of the FIR through additional affidavit.
In the meantime, if possible, kindly interim may be protected. Otherwise,
We don't know whether girl is recovered or not.
CD on, my lord,
CD on 38.
38.
1-3.
1.
obliged.
May I please, your lordship? This matter may be taken after some time, my lord. After some time. A blessing.
My lordship. Lordship, this is an anticipated bail application, but it has been filed without FIR, lordship. What has happened is petitioner number 1, he is a married person, lordship, but from last around 1 month, due to some familial issues, his wife has been living in his maternal house. But lordship, from last around 7-10 days, the police has been repeatedly calling him and his mother and another petitioner to come at the police station, but no any summon, no any written information has been provided to him. In fact, they have been going to his house also to search for him, but no any information, what allegation, just they are saying that his wife has lodged some FIR in the police station, lordship.
You were not, you are not shown the FIR
No,
copy.
lordship, no any summon, nothing, lordship.
And notice you have not received.
No, lordship. We have made specific statement in paragraph number 4, lordship. This is the all women police station, Pandoda.
All women police station. Pandoda.
So
At this, we can call for the
at
report
this stage, lordship, short date may fixed and the
short date we don't. This week we are not going to fix, maybe and
next week early, lordship.
We'll see it. You are Mr.
NZ Chaudhary.
Hard Mr. NJ Chaudhary, Delaney counsel. Hard Mr. J. Delaney additional PP, payment. This is an application of the section so and so. So apprehending arrest in apprehending arrest by what police station this is?
All women police station, Pandoda.
All women police station. Next, submitted by Mr. Chaudhary that without any written information or without FIR, the police is harassing the present petitioner, stating that some complaint is lodged in state police station by whose wife?
Petitioner number 1's wife,
Wife
lordship.
of the petitioner number. And hence the report the petitioner has the apprehension of arrest in connection with business. But in view of it, later police report be called for from the officer in charge of all government police station as to whether any case has been registered. Yes. This is the matter on 12/8.
Well.
It's on 12.
Lordship, next item is also similar, just the police station is different, Lordship, it's the Hatigaon police station. Similar situation,
Or
Lordship.
same
Yes, Lordship, similar kind of situation,
how
Hatigaon police.
how two cases were there? I mean,
Because Lordship, since two different police station, Lordship, so we have filed two different ADs, Lordship. Police station is different.
so from two different
Yes,
police
Lord.
stations you were searching for.
Yes, Lordship.
It is Hatigaon.
Yes, Lordship. Second one is
Of the
Hatigaon.
same allegation that your wife may lodge an
Yes, but similar kind of allegation, Lordship.
same order. Okay.
Of the.
We are not able to make communication with the accused petitioner, Lordship. So notice may be go for mediation. Notice.
Here the name of 1, 2, 3, 4. 4 councils have been reflected in the cause list. Oh, you are one of them. You are for the respondent.
Yes.
Now you could not make any contact with your petitioner, that is accused.
Yes, Lordship.
What you want to submit here? It is a case of NIA or what?
The enhancement petition, madam.
Enhancement, maintenance.
Maintenance.
So what is the position now?
Position,
Your
madam,
your
last-
respondent is getting any
Last 4 and 5
maintenance?
years, my lord, I have no contact with those petitioner, respondent, my lord. This is a difficulty, my
You
lord.
also don't have any contact.
My lord.
So at present, your respondent is getting any.
In data, my lord, 21. 2021, we have written a letter to the respondent, my lord.
Otherwise, it is a case of 2012.
My lord. Whether
But it's
he's
21 it-
married or he's alive, by no instruction, my lord.
And you also don't have any
No.
instruction.
In the matter, we refer to the mediation, my lord. Mediation will issue notice to the
Let us see, without the parties, how can we send it for?
my lord.
We'll make a try to register, we'll send a fresh notice to the both the parties.
My lord.
You are Mr.
D. Bora on behalf of Mr. H. Das.
Are Mr. D. Borba appearing on behalf of Mr. H. Das and also Mr. You're
AK
Mr.
Azad. My name is not there, my lord.
You're Mr.
AK Azad.
AK Azad. AK Azad for the respondent. But the case was identified for to send for mediation under the special mediation right. But it is submitted by learned counsel to both the parties that they could not make any contact with the petitioner as well as the respondent since last 4 or 5 years. 4 or 5 years. In view of this, the registry is hereby directed to take state in issuing notice both the both the petitioner as well as the respondent, and in the event of the service of notice that a matter may be referred listed. When I the mediation complete mediation নাহে কি কৰিব এইবিলাক স্পেচিয়েল মেডিচিন লৈছে কেছবিলাকে নাথাকে কাটি দিছে If non application court state is one of the party here at criminal petition, state is one party here. Pick up Assam and another Assam, no, nice another one. The non application call for the petition Heard Mr. Jisutia, the learned counsel appearing for the state response. And the respondent number 2 is also remain under. In in view of this, the matter could not be sent for mediation. However, the registry is directed to take steps in issuing notice on the court petition and its court. In the event of a service of notice to the parties, matter be referred to this step.
Please.
I'm appearing for phone number 2, Lordship. It's an NIA case, conviction under for 6 months and compensation of 2,60,000.
So is there any probability,
I'm for a complaint. I'm ready. I'm for a complaint. Accused, yes, sir.
that's what you're for the respondent?
I'm
complaint.
for respondent number 2. Check amount was 1,90,000.
And on 3/6/2020, an order was passed, wherein it was most probably submitted before the court that on 4/5/2020 it was suggested before the court that a process was going to make a settlement outside the court.
That is from their
Today,
side.
Mr. Jain has submitted that the process is still in progress, and there is likelihood of reaching the settlement within a very short period. But there
Till now, there is no settlement.
no settlement.
No settlement because it was
As per
submitted
your
by
information.
change. But till now, there is no settlement. Yesterday or any there was no settlement.
None appears on court petition. Mr. Detail of the learned counsel acting to respond. It is submitted by Mr. Talbot that the complainant of the respondent will not make any contact with the petitioner accused, and there is till date there is no settlement as per these instructions. On next one, on appraisal of the record, it is seen that on by the order dated 6/2020 was intimated to the court by the learned counsel for the petitioner in regards to progress of settlement between the parties. But till date, there is no such settlement. But till date, as per the respondent, no settlement has been made. In view of this, let a fresh notice be issued to the accused petitioner. Registry will within it. In event of the service of notice to the petitioner, that may be referred. So through registry, we are
Okay.
going to
Notice,
do
send notice to the petitioner.
wait of this petitioner.
Okay.
And in the process, if there is any possibility, then matter. Otherwise,
Otherwise,
is
it's
there any
fixed for
stay
here.
order? Stay order was there.
Stay order is there.
So that will be vacated. In the
That's much.
Wait, wait, Lordship, the talk for amicable settlement is going on between the parties, and they will come up with certain settlement agreements, but we are not currently updated with the status, what's going on in the DV case. So, Lordship, kindly give us
this matter is out of DV.
DV case, Lordship. Yes.
So from where you are saying that the settlement is going on outside the
No, actually, I have got the instruction from the clients, from the parties.
outside court.
Outside court settlement.
So you are for the petitioner.
Petitioners. Interim was, the matter is stayed actually, but we'll come up with some settlement agreements and we'll let the court know about it. Kindly fix the matter after 1 week. Lordship.
You are Mr.
US Bora.
Heard Mr. US Bora, the learned counsel for the petitioner. No one had represented the respondent. However, it is submitted by Mr. Bora that talk of compromise is going on between the party outside the court, and there is every probability of settlement of the matter outside the court. Accordingly, he submitted that some more time will be required to place the position to submit or matter may be required for the state. In view of this, let the matter be listed after 1 week.
After 1 week,
After
can you
1
fix it, Lordship, so that we can?
You come and after you approach the registry, we are
Lordship.
eagerly waiting for
Lordship.
any compromise, in fact.
Lordship.
If it is there, then it's a good sign. Okay, then. We are listing it after 1 week as on a date to be filled by the registry. If there is any settlement, you just make a mention before the registry so that matter may be listed.
We'll seek instruction.
1 week. You
1
need
week.
1 week, no?
1 week, Lordship.
8 and 9.
Very civilized.
But please, Your Lordship, my lord, would
You
your
are
lordship,
appearing on 8 or 9? 8.
your lordship, please to take 9 man.
9. 9 you are appearing.
Yes.
Why it is connected matters or what?
Yes, both are connected. The thing is that 8 is the principal in charge. He already retired, and me, the 9. I was the president of that high secondary school. I have also finished my terms and gone. Over the case is nothing, my lord. Those old schools, they had certain trees. The trees become very old, and it was danger to the students. So what the managing committee decided that we'll cut these trees and we'll go for new trees. And they have decided to build some desks and bench for the school. So they cut the trees, and with that tractor, they were supposed to take them at those logs to the nearby sawmill in order to get it ready for the decks and bench. Both these persons are reputed persons. It is not that they were trying to take away the logs or anything like that. But
Without any approval from the concerned forest department or whatever, you cut all the trees.
no, only 3
Why?
trees. Only those 3 trees. My lord, I did not cut. It is the school.
You are the managing committee.
Yes,
You
yes.
cut the tree.
Yes, what I'm saying is school managing committee. My lord, at that time, my lord, everybody, we have all gone through the school life. The trees have become danger to the students' life. Suppose there is a big wind comes.
So what prevented you to at least minimum intimation to the department concerned? You could have.
No, they have taken the plea that they thought that, my lord, these are in the school ground, those trees. They can use it for the school purpose.
Anyway,
It is
this case is now at present, these are cases we identified for referring to the mediation. If you think that it will be, helpful in referring to mediation, then it can be referred. But the question is that this law point cannot be decided in the before the mediation. But I don't know, there may be some reason why it has been selected for referring to the mediation. Now, what do you say? Can it be referred? What you want to submit?
my lord, as your lordship is aware that, my lord, only that if the question of that forest law comes, then possibly the mediation
may not reach.
May not. So, my lord, let it be here, my lord. Let it come for final hearing, because ultimately it is only the state versus us. And the proceeding is state. And these persons are, I think, one of them is bedridden.
So otherwise you are appearing for 9.
9.
9 you are.
He's for 8.
I am for the 8.
8. Otherwise same situation.
Same.
Same situation, but FIR is different.
2 FIRs.
2 FIRs.
1 year later, madam. I didn't. Different person.
8. You are Mr. 8.
K.I. Mazumdar.
Mr. K.I. Mazumdar, 8 to petition. Also had Mr. Desputia, addition. You also see the question. Is there any involvement of the law points may be there because settlement cannot be possible before mediation. And also had Mr. Desputia. The case is identified for referring to the mediation, but it is submitted by Mr. Mojumdar that there are some law points involved in the alleged content which may not be settled before the mediation, and accordingly submitted that matter may not be referred to mediation and may be heard in the courts. And next para, considering the submission made by the counsel for petition and on basis of the case report, considering the nature of the allegation, find that it may not be a fit case to send it for mediation. Next, according the matter may be listed for hearing. And now then it will be listed for hearing, or what is the stage now?
Lord, proceeding is stayed, my lord.
No, proceeding is with hearing stage only.
Yes, my
But CD or anything is called for?
lord.
Do you have any instruction that CD or whatever is called for, or not yet called?
Lord,
Copy of the petition
But I think in the first order only the notice was
issued.
issued.
List the matter accordingly in the order column. After 2 weeks,
After 2 weeks.
same order written. And you are Mr.
Javedin.
Javid. And 9 of Mr. Javid. Same order. We were not sending it for mediation. We're listing matter may be listed here in the order column. We'll take the steps.
My lord, there was a stay order, my lord, in both.
Both the matters.
Yes.
Interim order be continued till next.
God bless you.
My lord, in my case, the interim was passed until further order, so not triggered.
You're in item number 9.
Item number 9.
Okay.
It was already until further
Already
order.
done.
Deeply available.
Yes.
This prisoner before Lordship, my lord, the case registered under section 376D, 379, 506 ITC. It is a succeeded case, my lord, where FIR, your lordship will find at page 10, my lord.
Page 10.
I mean, Robibul Hussain, Robibul Ali, my lord, it means that 11 is the. It says that most respectfully, I beg to state that I am the resident of so-and-so. I stay at Guwahati for my livelihood. I had a lab affair with Nur Alam of village Bairar Farm under Mandya Moza. Yesterday at 28/3/2021, Nur Alam took me to a motorbike at a so-and-so who wanted to marry me. After having tea at Mandya Bazaar 8:30 p.m., when I got up from Ahmad bike, approached the accused person along with 10-12 people, came and took away Nur Alam along with his bike. With the help of accused number 2, the accused number 1 took me in his 4-wheel vehicle, bearing registration number so-and-so, and taken to Adhar Vidyalaya near Mandya block and forcibly wrapped me against my will. With the help of accused number 2, accused number 1 threatened to kill me and wrap me. And besides, the accused number 1 and 2 snatched away my mobile phone worth ₹20,000, 1 pair of bangles, and said not to express the incident to anyone. He told me that he may kill her or whatever he says. Already accused number 1 and 2, all their friends, approached 10-12 people over phone at the place of occurrence. The others are disturbed me the whole night as a play dog. They came me in the whole night today on 29/3. They came me in Mandya Wood Market, call upon Nur Alam after taking ₹9,000 from Nur Alam. They handed over me to Nur Alam, and they also said the bike of Nur Alam will be returned after payment of 20,000. Presently, bike of Nur Alam is still in the accused person, RC number so-and-so. Therefore, kindly investigate the matter, raised the case. So that is the prosecution case, my lord. Subsequently, my lord, during investigation, my lord, she was medically examined, my lord, by the doctor, my lord. That medical evidence, however, I have not enclosed, my lord. That I can say, my lord, medical evidence was done on the basis of GD entry number 16659 of 21. This is prior lodging of the FIR. That was on 30/3/2021. And according to GD, because according to her, she was sexually assaulted on the night of 28 May. 29, she was recovered. And on 29 itself, a GD entry was lost. Thereafter, on next day, she was medically examined. And as part of medical report, my lord, The opinion is that no evidence of sexual intercourse, the nuisance of the above named examination, no evidence of injury detected as per the body, and this he is not suffering from any mental or physical disability, no evidence of any particular foreign clothes or a violence victim change. So nothing was found so far as the medical evidence. Now subsequently, my lord, after charge sheet was submitted, my lord, that is on that I am enclosed along with the copy of the subject. You will also find at page 15, my lord, and 2, my lord. That already three accused persons were made with charge sheeted, my lord. That is one, Rabiul Hussain, Mohibul Haq, and Kajibur Rahman, my lord. And the charge sheet was submitted by charge sheet number 143 of 2021, my lord. And thereafter, and he was found as absconder, this present petitioner. And accordingly, this charge sheet was thereafter with the committal code, my lord, by the order dated, that is page 22, Annexure 3, by the order dated 15/2/2025, was pleased to accept the report of the inquiry officer regarding proclamation of attachment and accept the same and declared the present petitioner as an absconder, and thereafter committed the case to the Court of Session, my lord. And accordingly, learned Session Judge, my lord, that is Corpeta, my lord, it was sent to the Additional Session Judge, my lord, on 28/2/2000. Case appeared before it was committed to the sent to the transfer to the court of page 25, my lord. And on thereafter, the charges were framed. That is page 27, my lord. Formal charges under section 376D, 384, 34. 379 is not there, my lord. So extortion is there, and 376D, 34 IPC was framed. And thereafter, matter has been fixed for evidence. And so I was declared absconder, my lord. But from the order itself, it appears that on the basis of a report submitted by the inquiry officer, my proclamation attachment, the order has been, I was declared abscond. But that report, because my case is that it was never executed, it should have been published in the locality. That is as per section 80, that has not been done. Anyway, my lord, fact remains that the whole arson, my lord, is totally inconsistent with the medical evidence. Basically, that is my case. So in that case, my lord, the way she has, manner in which the occurrence took place, she has narrated, my lord, that I was assaulted by two accused persons. No injury, nothing was found, my lord. And so, and prior to lodging of the FIR, there was GD entry. So we don't know what is the GD entry, because she was examined on the basis of the GD entry number 659 of 2021. And FIR was lodged subsequently, that is by GD entry number 660, my lord. Your lordship, so my prayer that since it's already such a case, I may be allowed to appear before a trial court and face the trial, my lord. That is my submission.
This is an anticipatory bail, my lord. Petitioner is an absconder, my lord, during investigation. Ultimately, my lord, proclamation and attachment also issued, my lord. Offense under section 376D, 384 and 34 regarding other accused persons, my lord, B1 Mohibul Haq and Sri Gazibur Rahman already charged framed under section 376D and all 384 and 34, my lord. And regarding the, my lord, without any inquiry that proclamation issued, I have also flag marked the inquiry report 161, 164 statement of the victim girl, my lord. And there are specific incriminating material against the accused persons. And my lord, there are several decisions of the Supreme Court also that absconder accused, my lord, should not be allowed to go on anticipatory bail. Regarding that aspect also, my lord, I have decisions with me, my lord. So this is not a fit case at this stage for granting anticipatory bail to a person who has committed, my lord, class A heinous offense. Regarding those, my lord, inquiry report and everything, I have already flag marked. So this is not a fit case for anticipatory bail.
Anticipatory in the sense, my lord, actually now, since the charge sheet has been submitted, there is only warrant has been there. No date has been given, only warrant has been issued, my lord. I want to face the trial for that. That is the matter. Police को दो दो यार.
I'd like to press through decisions of the Honorable Supreme Court. Madam. One is sufficient. It will- Paragraph 16, my lord, last page. Given the observation while granting interest. It will-
Parties to be the learned counsel for the petitioner, so parties to be the learned petitioner to be apparently an application, section so and so. Okay, submitted by Mr. for the representation is not permitted in such form as that whenever is lodged against the present petitioner along with other persons alleging sexual alleging alleging gang rape on him, as well as there was other allegations of this theft. But the present petitioner is not aware about the tendency of this case. He was never searched by police during the investigation. Further, he submitted that from the medical report of the victim, it reveals that no injury was detected by the PSI officer at the time of consultation. And she was examined immediately on the next day of the entry of the GD next day of the recording of the GD entry number 659. However, the FIR was lost subsequent by the victim, which was registered. Further submitted that the accused petitioner was shown as an absconder in the charge sheet. Though he was never searched by police during investigation. However, the present and investigation subsequently the NVW was issued against the present petition. Subsequent, considering the report of the executing officer, he was declared as an absconder and case was committed for remaining 2 other accused persons. The done session just for the frame charge against the 2 other accused persons under section 376D, 384 by 34 IPC, and presently the case is before. However, the present expedition is ready and willing to appear before the learning session judge and to contest the case by appearing regularly before the court if he is provided with some information so that he can appear and contest. Next, Mr. Gordon learned and people raised payment objection and submitted. The present petitioner was shown as an absconder and the record reveals that he never cooperated and there are sufficient incriminating materials brought against him by the victim while record while recording a statement, the section 164 is next. Mr. What further submitted, there is various observation of the Honorable Supreme Court, where it has been observed that anticipatory bail cannot be granted to a petitioner who is declared as an abscond or as a proclaimed offender. In that context, he also relied on the decision of Honorable Supreme Court reported in 2021 0 AIR bracket of SC 5125 and basically relied on para 16 of the say which we 16 to my point is at the time from security. We also relied on the decision of Honorable Supreme Court passed in case of Srikant Upadhyay and others versus State of Bihar and passed in criminal appeal number 1552 and 1552 wherein also same expression, same view has been expressed by the others. Hearing this submission made by the counsel for both sides and supervised case record and the case record and the scan copy of the DCF. It is seen that from the DCI it reveals that sufficient implementary measures are found against the present petitioner, on the basis of which the charge sheet was filed against him, showing him as an abscond. From the appraisal of the record, it reveals that the petitioner never cooperated in the investigation during the investigation of this case, for which he was shown as an abscondent in the charge sheet. But it is seen that the learned Homicidal court also took several steps and took all endeavors to procure the attendance of the present petitioner and the petitioner, but he avoided the police arrest and finding no other alternative. A NBW along with PNA was issued against him, and considering the report of the executive officer, the present petitioner was shown as an abscond, declared as an absconder, public proclaimed. Next, in view of this, considering the gravity and nature of offense vis-a-vis the conduct of the accused petition, I do not find it fit is to extend the privilege of the arrest bail to the present his petitioner state. However, he is directed to appear before the learned session judge with an appropriate application for bail, which may be considered in accordance with observation. Your interim prayer is bail prayer is rejected. You are directed to appear before the learned session judge with an application for it.
Additional session judge.
Additional session judge. Additional session judge where it is?
Borpeta, ma'am.
Borpeta. Additional session judge. Borpeta. Okay.
Yes. My lord, and this is regular bail application, lordship. In this case, lordship, this RCT already been submitted and the petitioner name is not in the FIR also, lordship. But for a moment, lordship, for the clear of the fact, lordship, kindly come to page number 38, lord. part of the charge sheet, Lordship. And last
38.
38, Lordship. And last part of the last para, Lordship. May I read, Lordship? Then the fact will be clear, Lordship. Last para, Lordship. The IO visited the PO and drawn rock sketch map and PO and examined the complaint and witnesses and recorded their statement under section so and so. After recording the statement of the witnesses, it is come to light that on 9/8/2024, deceased person along with his girlfriend, namely Hiya Sarkar, and other friend went to Parvati Pahar at Boko. At Parvati Pahar, deceased and his girlfriend went to the lonely place and engaged to obscene act which was photographed and videographed by two local persons. Later, they demanded 5,000 from the deceased person and told that if they do not pay the said amount, they would inform two parents. And deceased Pavitra Mondal somehow managed to pay 2,000 and 800 rupees paid through GPay, deceased friend, namely Pranab Roy's mobile phone. Pranab Roy, friend of deceased, linked his father bank account use Google Pay. Accordingly, bank transaction, the father of the Pranab Roy, namely Nivasi Rai, so and so, account number so and so, bank so and so, and has been taken out from the Sargaon branch. And from the bank transaction, it is come to light on 9/8/2024 and so and so, 800 rupees transferred to Bhumidhar Rava, Lordship. And this must only the allegation against the present petitioner, and they are now about 1 year in custody, Lordship. And only 800 rupees. But there are some other person also, they were carried the person, and there were some in inappropriate manner, Lordship. And someone, Lordship, and took some photos. But
No,
they
you
are
are
on
Nayan Rava, and what is your account? Through your account?
Bhumidhar Rava, Lordship. Not
No,
Rava,
you are
Bhumidhar Rava.
Nayan
Only
Rava
800.
and Bhumidhar Rava.
Lord. But I am the Nayan Rava is the friend of Bhumidhar Rava, Lordship. So otherwise, Lordship, they have the informant son is commit suicide, and the FIR it's very much clear, Lordship. Kindly come turn to FIR, Lordship, will find page number 21, Lordship. FIR. May I read, Lordship? 21, Lordship. With due respect, I beg to state that on 10/8/2024 in the morning hour at about 7 a.m., I got information from the local Gao Pradhan over telephone is that my son Pavitra Mondal committed suicide by hanging on a tree located at Gumi East cutting site. About this incident, local Gao Pradhan came to learn from Agmuni Gao Pradhan by WhatsApp, and Agmuni Gao Pradhan came to know about the incident from police. And the police, the place of occurrence is about 2 kilometers away from my house. One boy, namely Newton Ali, informed about the incident to the police on last night, and through this phone number so and so. And after that, police brought my son to the police station. It is suspected that my son Newton Ali were in relation with the girl, namely girl Hiya Sarkar, daughter of so and so, so and so. So, my lord, the petitioner involved.
Hiya Sarkar is also
The
one
deceased
accused.
girlfriend, Lordship, and they went.
No, she is also an accused.
No, Lordship, but she is not. Even the Pranab Roy, Lordship, there is the transaction 800 to his account, but he is not also the accused here. So,
No, how you are related then? I could not follow it.
Pranab Roy is the friend of deceased.
Ah.
And some other local person, when they caught them in appropriate manner at Parvati Pahar, and subsequently some of them, Lordship, and demanded rupees 5,000. And if they do not pay the amount, they will be viral the picture, their options photos. And subsequently, Lordship, the present petitioner, the Bhumidhar Rava, Pranab Roy is the friend of Pavitra Mondal, deceased, and he sent 800 rupees to the Bhumidhar Rava, Lordship. On that basis, they are the link in this case. Otherwise, Lordship, they have no.
So you accepted the money that means.
Lordship, otherwise, Lordship, that is their Lordship, that is account pay.
So why he committed suicide?
Lordship, there is nothing, Lordship, and otherwise, this commit suicide actually, Lordship, and the charge sheet part is, Lordship, and I'm coming another part, Lordship, next para, Lordship, page number 39, and second para, Lordship. Visited the house of Hiya Sarkar, girlfriend, deceased person at Singimari under Goraimari PS, but found mother of Hiya Sarkar present at home and informed her to ask her husband, namely Nipen so-and-so, to appear the Soigao next day so-and-so. And Vishwanath Sarkar's uncle and so-and-so is PS so-and-so and with Hiya Sarkar. After recording their statement, it is come to light on 9/8/2024. Hiya Sarkar went to the Parvati Pahar along with her boyfriend. They went to the lonely place and kissing each other, which was videographed and photographed by the local people. Lordship.
So they blackmailed those two.
So my lord, and other is lordship that must
Anyway, what is
lordship,
the
and it is
position of the case at present?
lordship is evidence is test lordship.
Is there any evidence
Evidence.
recorded now?
Perhaps lordship two witness already been
witness.
examined. Lord. But about 1 year lordship they are in custody. And otherwise lordship the section 308 lordship only extortion part is there lordship, it is admitted fact. But suicide is that is lordship no related. Only that must 800 rupees. Lordship.
My lord, I have gone through the record, my lord. Lordship is rightly pointed out, my lord. What are the person, my lord, who demanded money 5,000 rupees? Otherwise, they threatened to viral the videos, my lord. When my lord here, Pavitra Mandal deceased, his girlfriend Hiya Sarkar and Pavitra Roy. All of the friend, my lord, they went to the Pahar, my lord. Then Pavitra were in different place, my lord, both of them. This is my lord, Pavitra Mandal is 18 years old. And girlfriend Hiya Sarkar is 16 years old. When they are in the particular place, my lord, some local people go there and photographs there, videographs there, and they threaten that my lord, 5,000 rupees is demanded. And if they are not given, my lord, it will air in the social media, my lord. Thereafter, what happened, my lord? They are in critical condition, my lord. They have taken 2,000 rupees from the other person, mama, and paid 2,000 in cash, my lord, and 800 rupees from the friend, my lord, Pavitra Pranab 800 rupees. Then after in the investigation, it was found that it was 800 rupees taken by Bhumidhar Raghav, my lord. And both of them, my lord, in this manner, my lord, they have demanded, and they are, my lord, 18 years and boy, my lord, when it was said that it will inform to the parents, and also, my lord, it was viral in the video, my lord, in social media, my lord. In this way, he has committed suicide, my lord, and such type of harassment, my lord. And both of them are involved, my lord. And one PW in the record, my lord, one PW examined, my lord, yes, categorically, my lord, said that both of them demanded money and rest the 18 years old, my lord, for that he has committed suicide. There is the
But lordship, this is lordship, there is no any note lordship. Otherwise, lordship, FIR parties does not disclose anything against the present petition. After 3-4 months, lordship, and this link is out by the investigating officer. Lordship. So, my lord, and another 2,000 is paid to some other person, lordship. But 800 only throw GPay, that is why lordship and
cash amount of
only not 2% lordship.
From
There
the-
one more person is there, lordship. So, my lord, my submission is local person about 1 year lordship. And so, otherwise, FIR does not disclose anything, lordship. And
Not
even then only
necessarily.
that much is there, lordship. It's admitted fact.
And the charging also reflects that due to the mental harassment of the my lord,
Lordship,
persons,
that
my
may
lord,
not be. Otherwise,
just
lordship,
committed
Pranab
suicide.
Roy, and he received 800 rupees. So he paid 800 rupees for GPay, but he does not disclose anything, lordship. And
His
even
statement
then,
is there, my lord.
the
His statement is there.
disease does not reveals against the even then any hand root or dying
Not
declaration.
necessarily.
There is nothing, lord.
Not at this stage, my lord. Some of the vital witnesses is yet to be examined, my lord.
Extortion part is there, lordship. 800 rupees. So honorable court, lordship, but already about 1 year, lordship, 9 months, something, lordship.
I have played back, my lord. All of the witnesses said that here Sarkar is also in the statement, my lord. Oh, his statement, my lord.
And even my mobile phone already been seized by the police. And there are some local person also there, another person. Yeah.
So we have some implementation.
Right.
The implementing method is against demos.
Right.
And what about the vital witness to whom you are appointing as a vital witness?
My lord.
Vital.
Oh, my lord, here, other witnesses are yet to be examined, my lord. Vital witnesses, my lord. Only one witness is here in the, my lord, charge sheet 17 PWs are here. Out of 17, only one examined.
They are in custody since last 10 months. That is there. Why is obviously there are some metrics.
And only charges frame 1/5/2025 in the month of February. And just under 3082 and 10835.
And the lordship.
And PW was examined on 5/3 March in the month.
Lordship, one thing, Lordship, and the abatement part 108, Lordship, abatement part is actually, that is the subsequent fact, Lordship. That because there is nothing, any statement recorded from the deceased, and even then he has not.
No, when
Not
when
necessary.
he committed suicide,
Right.
subsequent. There and there he committed suicide, or he came home and then
Right.
came home.
Hmm.
After reaching home, he committed suicide, or there in the spot itself.
No,
No,
after committing harm, Lord, subsequently, Lord. Later.
As per you, some of the vital witnesses are yet to be.
Right. Otherwise, it will be difficult to prove the case means. If he is released on bail at this stage, he may hamper or temper.
Mr. And also had Mr. Bishop. This is an application under section 20 in connection with suicide. Thank you for that. This submitted by Mr. Hawk, the counsel for the petition, that both the petitioners are not involved in the alleged offense. However, it is a fact that at the place when the victim and the deceased was when the deceased and her girlfriend was together. However, it is a fact that both the petitioners were present at the place of incident, and some of the local persons demanded some money from the deceased. But the present petitioners are not involved in demanding money. But it is a fact that rupees 800 was deposited in the account of Bhumidhar. One is Bhumidharma and one is Noyan.
No. Noyan is only, his part is that he is the friend of Bhumidhar, Lord. But he has no.
Bhumidhar Rava. Bhumidhar Rava, which was paid by the friend of the deceased at the time of that apart, there is no role of these petitioners, and they have not committed as a so the petitioners are behind the bar since 15/10/2024, and hence considering here their period of detention also, they may be released. two witnesses have already been examined by the prosecution, and the case is at the stage of however, both the petitioners are ready and willing to cooperate. I hope ready and willing to appear before the learned trial court below and to contest the case if they are provided with the privilege of. Next, one, Mr. Sharma, the learned petition will be submitted to the question. That these two petitioners are fully involved in the alleged efforts in demanding money to the deceased and also threatened to make viral some of the videos and photos of the deceased with his girlfriend. Two witnesses have been examined out of 17 numbers.
I have found only one, but one. I have found
one
only-
witness is only examined out of 17 numbers of witnesses, and hence and some of the vital witnesses are yet to be examined. Thus, there is every probability of tampering or tampering with the evidences of the other witnesses, especially the vital witnesses of the prosecution. And accordingly, Mr. Sharma raised objection in allowing the petitioners to go on bail at this stage. Next one. Hearing this submission made by learned counsel and squared is and is can copy of this here along with the testing. This seems that there are some implementing materials against this petition, especially involved they were involved in demanding money from the deceased and from her. However, considering the period of detention already undergone by the petitioners, find that further detention, further custodial detention may not be required for the interest of the case. It's find the fitness to extend the privilege of bail for the petitioners with the direction. To the whose satisfaction it is?
The Chief Judicial Magistrate Kamrup Aminga Lord.
No.
Sorry, session, district and session just Lord. Now, additional session just Kamrup Aminga his trial is going on.
To the satisfaction of additional session just Kamrup
Aminga Lord.
Go to Marathon Bill. Forward. To Mark Mood.
Deeply obliged, Lord. Obliged.
My lord. 5 copy at page, my lord, 11, my lord, is a definite copy. It is a case of, my lord, 2015. And this case, my lord, 55/2015 has been registered corresponding to a GR case number 1438/2015, my lord. Now, my lord, in this case, my lord,
2015.
my lord, this is, my lord, registered pursuant to a GR case number 1438/2015, my lord. And in this case, my lord, a petitioner was actually released on bail. And before that, my lord, I took your lordship to Annexure 2, page 17, my lord. And there is an order 21/116, my lord. Now, in this case, in this order, my lord, the petitioner was shown arrest, my lord. Meaning thereby he is under trial prisoner. And there is another case 151/2015 under section so and so and so, my lord. Now, my lord, next page, my lord. In
So
page
arrest in connection with this
150
case.
in PS case number 151/15.
In connection with Kajigaon PS case number
No, my lord,
55.
no. Bogribari PS case number, my lord. This is, my lord, just I am referring to, my lord, to appraise the order. Now, my lord, next page, this is vital, my lord. This is related to Kajigaon PS case number 55/15. Next page, page 18, my lord. Annexure 3. 29/4, order dated 29/4/16, my lord. And the top, my lord, it is UTP MD Mir Hussain. Actually, it should be Mir Hussain, under trial prisoner Mir Hussain. And now, my lord, on 12/5/16, he was produced before the trial court. And now, my lord, I'm reading it, the relevant portion. It appears from the record that the accused person, namely so-and-so Mir Hussain, shown arrested on 21/1/16. Since then, accused person retaining in jail Hazor and completed the statutory period of 90 days. The report under section 173 CRPC has not been laid down, has not been laid by IO, as the said accused person is allowed to go on bail of so-and-so amount, which one local surety. So he was allowed on bail, my lord. Now, my lord, this case was committed to the learned session judge, my lord. Page 19, my lord. The whole problem started here, my lord. Now, my lord, after committing this case to learned session court, by case number 86/2022, my lord, the proceeding started there. But unfortunately, my lord, the petitioner is a daily wage labor working in a brick industry, Itabata, somewhere, my lord, out of his place, my lord. And now, my lord, this petitioner, during this, my lord, trial before the session course, did not receive any notice of whatsoever.
Just one. Here, the order of the sessions, it is seen that 22/4/2022, the order was passed, and the fixing 25/4/2025 for production.
Yes, my lord.
How can it be possible?
My lord, this I'm
Say
coming
after
to
3
it.
years, after 3 years.
My lord, I'm coming to your lordship, my lord. Now, my lord, your lordship, kindly come to the page number 20.
No, see, why it is after 3 years?
My lord, so far as my lord, as I have been informed, my lord, the case record has been transferred from the lower court to the session court, and in that procedure, my lord, there is a delay. So far as I have been informed by the brother of the petitioner.
No,
This case has been transferred
I'm
from
not on that.
my lord.
Question is the order was passed on by the session judge Kokradhar on 22/04/2022. Produce the case record, the case accused person, namely Mir Hussain, is in jail. Fixing 25/4/2025.
Page number, my lord, page number, my lord, kindly, page number.
Page 19.
19, my lord.
Why it is after 3 years?
There is, my lord, fixing 25/4.
Yes.
25.
25/4/2025. Is it a proper, is the correct certificate copy, or you have typed
My
it,
lord,
or
that's
what?
why, my lord, the LCR has been, my lord, asked to call for. That's why, my lord. Now, my lord, before, my lord, to argue on this, my lord, next paragraph, my lord, so far as your lordship may kindly peruse correctly, next page 20. Order written 19/5/25. Seen the petition, may I read, my lord?
Yes.
Seen the petition number 1599/2025, filed by the petitioner, so through his engaged counsel, praying for granting bail to the accused person, namely Mir Hussain. A copy of bail petition is furnished to learned PP, Lahad learned counsel and learned PP. Learned defense counsel has submitted that due to non-appearance of the accused person on several days, the Honorable Court has issued NBW. The accused person was arrested by the police in the strength of NBW in connection with PRC case number so and so, and since 11/3/25, he has been linguistic in jail Hazor. Accused is the only breadwinner of his family, and his family fully dependent upon him. He will regularly appear before the Honorable Court to face the trial if he is allowed to go on bail. Peruse the case report, accused was declared expungered by the learned magistrate after execution of PNI issued against him. Hence, considering the conduct of the accused, the bail petition filed by the accused Mir Hussain alias Hussain Ali is hereby rejected. Now, my lord, I am, my lord, we are appearing before your lordship, my lord, challenging this order, my lord. This is, my lord, again, my lord, the committed case, that is, my lord, session case number 86/22, top of the, my lord, page number 22, my lord. Now, what happened, my lord? That is case number, PRC case number 10/29, my lord. I have gone through the records through, my lord, through internet. It is found that in that case, one, my lord, your lordship kindly come to page my petition of page 6, my lord. Para 6, page 6 is the, my lord, main portion, my lord. I am reading from that on 11/3/25, my lord. Page 6, down 3 line below. That 11/3/25, my lord, you also got it, my lord. Page 6, down 3 line below. That on 11/3/25, the petitioner is, however, arrested by the Bogota police in connection with PRC case number 10/2019 under section so and so, railway section so and so, in which NPW was issued against the petitioner. Now, my lord, the said PRC case was registered in connection with FIR number 202/18, lodged against one Badsha Sheikh. In that case, my lord, petitioner was not FIR name. Even, my lord, in Kazigao PS case number 55, the petitioner is FIR name. And, my lord,
No, what do you want to submit, in fact? Because of
my
puzzling
lord,
all this situation. Just tell us what is your case.
my lord, since my
You're
lord,
not here to read all these things.
my lord,
Just tell us what is your
my
case.
lord, my humble, my lord, before receive, my lord, since, my lord, there is no prima facie case established against the petitioner, and, my lord, as many as, my lord,
Is
11.
such a case?
Yes, my lord.
Then
11.
prima facie, we are not going on that. What does it say about the conduct of the case? How long he is in custody?
My
Prima
lord.
facie is already there. If prima facie case is there, that's why charges is filed against him.
My lord, my
Don't go
humble,
by the merit of the case everywhere now. Now, what is your case now?
my lord, my humble prayer, my lord. Since, my lord, 11 witness has been examined, and, my lord, PWD
You are
10.
saying in 2019 he is there. You are saying 2017 he is there. 2015 he is there. So what is your case? We cannot follow you. Everywhere on pages, turning the pages.
No, my lord, and that's why, my lord, I'm only on, my lord, relying on page number 20, my lord, 20, where his bail application is rejected, my lord. I'm just narrating the what has happened, my lord. Now, my lord, it's a considered case, my lord. He is behind the bar since, my lord, 11/3/25, and, my lord, in, my lord,
Now in the present case, since when he is in custody? Just
11,
tell us.
11/3/2025, my lord.
Since
11/3/2025, my lord.
he is in custody.
My lord, my lord. And,
That
my
is
lord,
the case in connection with
Kazigao PS,
sessions to
yes, my lord,
86.
86, my lord, yes. And as many as, my lord, 11 witnesses has been examined, and, my lord, IO said, my lord, no material found against him, my lord. 11.
11 witnesses examined.
Yes, my lord. I have, my lord,
161 statement, my lord. It does not have
161 statement.
11 witnesses, how can it be examined within this?
My lord, 161 statement. I
my
am
lord,
referring.
160, perhaps he said
One 161 statement, my lord.
Yeah,
I'm sorry.
case is only for copy, man. Copy already submitted. Man.
Oh, not yet.
Not yet,
Charges
man.
not yet.
Not evidence stage, not yet.
PW1. PW1. My lord, in fact, my lord, I have, my lord, certified copy of the, my lord,
But deposition is
deposition is there, my lord. I have certified copy, my lord, with me.
go again, my lord. I have to again go through.
In
When
HPC public,
case was when committed?
my lord, in the year 2022, my lord.
Case was committed on 2000.
22, my lord.
Thank you. So if you want to say that the cases were the evidence stage,
Yes, my lord.
your petitioner was in between, he was absconded or what?
No, my lord.
Absconders PNA issued. Thereafter case was filed, and last order, Lordship may kindly produce the order, my lord. Last order dated 11/3, my lord. Here revived. Case was revived, my lord.
Oh, on his
That's why supplementary file submitted before the court, my lord.
Only thing after committing the
So
case, my
he
lord.
was absconding since
For, my lord. For a long time, my lord.
I have stated in my paragraph, my lord, in the petition, my lord, that since, my lord, no notice has been received. After, my lord, commission of the case, my lord, to
You
session
Mir
court.
Hussain.
My lord, Mir Hussain, my lord. And, my lord, after, my lord, during the, my lord, the evidence stage, The IO, they stated that no materials in found.
Mr. Sharma, just tell us one thing. As he was absent, in fact, he was declared as an absconder. The case was committed by this filing his case.
My lord, I think it's. That's why, my lord. That's why later on,
Is
perhaps
there any
the
order?
order, my lord. Lordship may kindly peruse the order, my lord. Last order I have taken, my lord. Perhaps he was split up his,
Split up.
my lord. That's why, my lord. I have taken I have not found that person. That's why I'm. 11-4, my lord. Lordship may kindly peruse first 11-3, my lord. Order, my lord.
11-3.
My lord.
Yes, it was on supplementary.
My lord, supplementary file, and here PNA issued a revive and restored to file. That will be our. Day after 11-4. The electrical one is going to be yes, yeah, in the split up for money. On the division of the year to here, yes,
All of miscommunication okay.
That's on the DNA is moved. I conclude. What the
Correct question. Yes, it's short. Mother ma. Diagram. Gusto
no,
mo
no,
inay puno.
no,
Inay.
several cases are also pending against him.
But not FIR minor. Only 2 cases pending.
3 cases I have found,
Including this one.
including
This one. No, your statement, well, nothing has been recovered from him in his cross-examination, my lord. Let's work it. Go back on it. Go ahead. Yes.
So you have annexed one order here at page number 19.
19.
Uh, wherein it shows
This is
that
a little bit also confusing.
that is refused the supplementary case received so and so along with so and so. Peruse the case record, the accused person, namely Mir Hussain, is in jail. So when he got arrested, the supplementary case record was there. But it cannot be 22/4/2020.
Perhaps it
There is
will-
no such order on 22/4/2020.
Little bit confusing, my lord. That's why, my lord, perusing the deposition.
Confusing, or I don't know where it is intentional or confusing, because there is no such order.
So, my lord, only
The 22/4/25 is not there.
no, I'll leave it to Lord. Say, my lord, only thing, my lord, since the deposition shows that as many as 11 witnesses examined, and there is no prima facie material shown.
Your conduct, who
My
will
lord?
see to your conduct?
My lord,
Regarding your conduct,
my lord, I'm regularly, my lord, appearing facing the trial.
appearing, no, you are in jail.
Yes, my
You
lord.
will appear now. You are in
Only
jail
thing,
now.
my lord, my lord, since my lord already
It seems that since 2000, earlier he was in
16
jail.
or 16 minute.
Since 2020 or something.
2016 minute, he was released on bail minute
Yeah.
for 90 days completion of 90 days minute.
Yes.
Then thereafter he is not minute available. Thereafter
Then
PNA
again,
issued
he was arrested most probably in
in another case minute. Here it was he was also arrested on 10 oblique PRC case number 10/19 minute.
In this case, my lord, he is not apparent, my lord, after commission of the case, my lord, to session court.
He got arrested most probably in the year 2020 here.
Mine.
And then again absconded. He was
Mine.
released on bail in 2020.
Mine.
As per my
Some
lord,
days, then he again
My lord. That's why it filed his case was filed. And one important thing is that my lord, regarding the my lord, present case, my lord, 55 my lord, 55 of 15 my lord. City party is also there, my lord. There is sufficient material against him, my lord.
no, whatever, my lord,
It is the matter of 395.
So in
Yeah, continue.
22/06/2020, he filed his bail bond, and thereafter he again
only thing, my lord, being a my lord layman and the daily wage laborer, my lord, working in a brick industry far from his home. And so, my lord, there is a miscommunication, my lord, might he have not noticed the notice as informed to me, my lord. So accordingly, my lord, he is working in the industry. So, my lord, thereafter one case has been filed. This is, my lord, PRC number 10/29. Not FIR, my lord, but on that basis, he has been he was again arrested, my lord. Only thing, my lord, any condition, my lord, your lordship, any condition, my lord, that may be imposed, my lord, and he will abide by those conditions, my lord, any condition, my lord.
You are Mr.
S. Loskar, my lord.
Begun a counsel for defense. Participation with the payment. This is an application connection. It is submitted by Mr. Laskar that the present petition is innocent. He has not committed any such offense as a resident here. However, he was no, but your intention that you could not appear, why?
Due to, my lord,
He is not shown as an absconder, I think. Shown as an absconder.
No,
in the chart.
no, my lord.
Not my lord. Here, in the 90 days, he was given jail, my lord. But after that, he's
That is after the case has been committed to session court.
During investigation also he cooperated with the investigating officer, and there is no such material collected against present. However, after releasing on bail, could not make contact with his engaged counsel, and hence the basis of MBW, he was arrested. But subsequently, he was also released on arrested, and since 11/3/2025, he is in custody. As revealed, he is in custody and shown arrest in the present case, who was arrested in connection with, as he was arrested in connection with in connection with PRC case number 10 of 2025 and 10 of 2025. Thus, the petitioner is in custody almost 5 months, and hence, considering his length of detention, he may be released. The cases at the stage of evidence, and in the original case, how many witnesses can you tell us?
My lord, 11, my lord. 11
11
witnesses
witnesses
examined, my lord.
examined.
Examined, my lord.
In the 11 witnesses have already been examined in the present case. Considering all these aspects of the case, he may be released. However, he is ready and willing to appear before the learned session judge on each and every date to be fixed by the court, and will if he is provided with the privilege of it. Next, Mr. Sharma, the learned section will be submitted that the accused petitioner was earlier on bail after at the time of investigation, after filing of the charge sheet. He again absconded after several efforts made by the learned trial court below. He was arrested in connection with the present case, but subsequently he again absconded and absconded. However, he was subsequently arrested in connection with another case, and since in another case and on the another case on the basis of warrant issued against him. Warrant issued against him, and then making a supplementary case record. His case was committed before the learned session. Mr. Sharma further submitted that in spite of several reports made by the learned trial court below, the accused could not be, the attendance of the accused could not be procured, and hence finding no other alternative, the learned trial court below had to issue NBWA along with PN, and considering the report of the executive officer, his case was filed and split up. Thereafter, the case was committed before the learned session judge for the process. So, considering the entire conduct of the petition, there is every probability of absconding if he is granted with privilege. Mr. Sharma accordingly raised payment objection in allowing the present petitioner on bail at this stage. Hearing this submission made by the counsel for both sides, I have also produced it and the scan copy of the DCR, wherefrom it reveals that the present petitioner was earlier granted bail before filing of the charge sheet, but after filing of the charge sheet, the accused remained absent, and on the strength of NBWA, he was arrested in 2020. Thereafter, the petitioner was allowed to go on bail on height order dated 22/06/2020. But since then, he again absconded, finding no other alternative. DNA and NBW was issued against him. And he was declared as an proclaimed offender, and case was split up for the other issues. It also reveals that he is not only wanted in the present case, but against him another 2 cases have also been pending, and on the basis of warrant issued in connection with PRC case number 10.
10/9.
10/9.
19.
19?
Test
19.
20. Test
19.
10/19. He got arrested, and then he was shown arrest. Considering the entire conduct of the petition, the submission made by learned petitioner PP Then submission, the probability of absconding of the accused petitioner cannot be rejected in view of all, and also considering the efforts made by the learned trial court below. I do not find it justified to allow the accused petitioner to go on bail. Accordingly, the bail petition stands. Your petition stands.
My lord, Madam.
May I please, your lordship, the seed was called for the shown arrest case, lordship. Shown arrested case, lordship. The lordship seed was called for, lordship.
She did not receive money.
Lordship, the today is 57 days, lordship, and 54 days, lordship.
Yes, it is otherwise 60-day office.
Lordship.
Yes, Sharma.
My lord, here requisition also sent on my lord 28/7 also my lord from Satgam.
Whatever he is in
My lord.
The
57.
length of condition, lordship,
My
and
lord,
the 48 of notice, lordship, not served, lordship, and no information to his family or relatives, lordship, in this case, lordship.
for 13 to
May I request?
30. No, 30.
13, 14, same, yes. Same place, 100, 100. হাত দাও
এটা হাত দাও এটা দি হাত দাও নেই
হাত দাও দুইটা
দুটা then metamine fiction at 2 minus whether CD is available or not.
Available.
Make please, your lordship. Petitioner was arrested on my lord 5/6/25, my lord, and today is 61 days, my lord. And mandatory period is my lord
5/6.
5/6, lordship. And today is 61 days, lordship. And length of detention is 60 days, lordship. Allegation is of abetment, my lord, and moreover, my lord, allegation of adultery, my lord. The petitioners, there is allegation in the FIR that petitioner has extramarital affair with the deceased husband of the deceased, lordship.
My lord.
That's why she committed suicide, my lord.
We will have to take instruction my lord whether charge is submitted or not.
I am told not submitted.
My lord.
My lord, moreover, petitioner has some health issues, my lord. And on 37, my lord, she was taken to civil hospital Tinsukia by the jail authority, my lord.
At 2 minus.
No, 108 is a 90 or 60 days.
My lord,
196.
60.
60 days, lordship. Up to, my lord, up to the extent of 10 years, my lord. So, my lord,
10 years.
up to the extent of, my lord, so 60 days. Lord. As per 187(2).
Which may extend to 10 years.
So in that case, it is 60 days. So now he is on 61 days. Is there anything?
Yes, lordship.
My lord, at 2 months. Whether charge is submitted or not.
She is lady, my lord. She is a lady.
Pardon?
She is a lady, my lord. She has some ailment, lordship. So, my lord.
Oh, he is saying that at 2.
Oh, obliged, lordship. Obliged, lordship.
May it please your lordship. My lord, regular bail application, my lord. The accused person was arrested on, with all respect, my lord, 24/5, my lord. As on today, 73 days. Possibly, my lord, they may not have the instruction, my lord, as it has already been filed. Because I could obtain a certificate copy of the charge sheet, my lord. Can I place it, my lord, for once, my lord, if lordship allows me? Please. My lord, may I kindly turn to, with all respect, 1, 2, 3. Lordship may leave 5 pages from the start, my lord. Come to the 6th page, my lord.
Page number.
The 6th page, leaving aside 5 pages from the beginning, my lord. Because no
Oh,
page
here.
number possibly
From
appears.
here.
My lord.
Oh,
From the certified copy, my lord.
I'm sorry. 6th page, my lord. Because no pagination is there, I think, in this charge sheet.
Yes.
Last paragraph, my lord. Facts disclosed during the investigation, my lord. Lordship has found it, my lord. Last paragraph, my lord. Here, what has happened, my lord? Allegation is of gang rape. Now, so far as medical is concerned, my lord, there is no sign of any injury, either on her person or on her private part. Then, my lord, if lordship turns the page, next page, my lord, FSL report is yet to be received, but due to, my lord, mandatory period of filing charge sheet is, my lord, progress, they have filed the charge sheet as per the second last paragraph of the next page, my lord. Third paragraph from up from top, my lord. I MR number so and so have sent to FSL, but the report is yet to be received. Several times I have sent prayer to FSL for collection of, but the report is yet to be received. I discussed the matter with my superior officer and OC Karimganj PS, and he suggested me to submit the CS. Now, if, my lord, one page I have flag mark, my lord, that flag mark, the other side of the page, my lord, victim is giving irrelevant history and seems disinterested during examination. So, my lord, as charge sheet has been filed, and I am in detention as on today 73 days, my lord. I humbly pray, my lord, with all respect, he may be allowed to go on bail, my lord, under any condition, my lord. No, he will be put me. Medical legal opinion is also there, my lord, the next page.
My lord, here Lordship may kindly peruse the page number 12 of my lord Azahar, my lord, FIR, my lord. What they have done, my lord, what their conduct, my lord. May I read only 2-3 line, my lord. I was executing night patrolling under so and so. Police river informed me through over mobile phone that 2 staff of CFB district jail, my lord, is the staff, my lord, has taken one unsound woman into their quarter and committed rape. They are in the security person, my lord, in the jail, my lord, but they have committed the offense, my lord.
Okay, we'll do one thing then. As he has submitted and certified copy is also produced.
Right.
Right.
That means charge sheet has already been laid. So let the scan
Minor,
copy along
minor,
with CDB
minor.
see to it.
Minor,
If there is any material that
Minor.
will be done, can we
minor.
will keep this one or you want to continue?
Well, I will
You can keep
reproduce it.
Yes.
Will.
I have noted down the number.
Minor. Yes.
Heard Mr. NJ Das, the done it counsel and also heard Mr. Bishop done it. It is submitted by Mr. Sharma.
247.
However, it is submitted by Mr. Das. The case has already been charged at CS number 247 dated 2207. Considering the nature of the case on other aspect of the case, let the scan copy of TCR be called for along with the case diary. List the registry will do the needful when it can be listed then.
In the month of August, after
2 weeks. After 2 weeks, any date will. After 2 weeks, any
After
date.
week then. After 2 weeks, any day.
Well, obliged. Deeply obliged.
May I please, Your Lordship? Case diary was filed.
well, here is charge sheet submitted, man.
That's still already submitted.
Well,
Yes.
one
CS number
well, charge sheet number 151 of 2025,
151 of 125.
dated 23/7/2025.
Your petition is in custody since when?
26th of June. 41 days as of today.
41 days. You're Mr. M. Yeah.
Right. Emma. Emma.
Emma. Heard Mr. M. Also heard Mr. Bishop. There are 41 days in case in custody, it will be mentioned. And CS number you have noted that. You appear before the learned trial court below with an regular application. And we'll mention that your period of custody is 41 days.
Deeply obliged, Lord.
That will be 30.
Yes, 18.
Manoj, here is also charge sheet submitted, man.
So you are in custody since when?
26/6/2025. 41 days, ma'am.
41 days.
Yes, ma'am.
Here charge sheet number 24 of 25,
24 of 25.
dated 30/30.
30.
6.
620.
This
You are Mr.
RIVR.
RIP. RIP naam to aase. It's in same order. He is also 41 days. You are 41 days in custody. So we have mentioned your date of custody, days of custody, 41 days. And you appear before the learned trial court below with a regular application copy.
Nineteen and 20 same CD, my lord. 19
Same
regular bail, 57 days. And next item is by the family members. AB, my lord.
Yes, what is the position?
Yeah. But the FIR, some construction is wrong, my lord, your lord.
You have received the case
Yes,
diary here?
video.
What happened?
Yes.
Case diary.
Yes, case diary received, ma'am. Case diary.
This is translated, fresh translated, I have given my lord.
We'll come to BA first.
Yes, BA first, madam. Item 19.
Yes.
Madam, page 13, your lordships. Barnacular, that will better, my lord, because English translation is not applicable.
Before starting, I would like to point out, my lord, regarding PM report, my lord, opinion regarding postmortem examination is kept pending till receipt of report from FSL Bongaigaon. And so, my lord, PM report is not conclusive regarding cause of death. And my lord, 2 FSL report, my lord, here received regarding that, my lord, from the blood sample FSL report, my lord, regarding that one plastic container, that report, from that report, it reflects that negative test for ethyl alcohol. So, my lord, poisonous, my lord, substance was not there. And here, my lord, offense is registered under section 103, my lord.
That's 302.
Yes.
And this is a FIR matter. All right, my learned friend, because medical part, so far, petition number, my item 19 is concerned, he is in custody. The others are family members, man. All the father, mother, and all the brothers and sisters of the accused number 1.
So suppose if it is taken into consideration that the case, cause of death or death is homicidal in nature, apart from that, any other, you want to submit on that?
Yeah.
Because FSL
FSL report
cause of
is
death is not yet known because
not
but
known.
can it be considered as a homicidal death?
Yes, my lord, because the suspect, he's a strong suspect, because from the, my lord, that FSL report of the blood sample, it is clear that there is no poisonous substance.
That's true.
And, my lord, from PM report, it is not conclusive whether, my lord, regarding cause of death. And from the PM report and on the immediately after kidnapping, my lord, on 6/6, 6/6/25, she was kidnapped, and on 8/6/25, my lord, victim died in the residence of the accused, my lord. And on that day, accused was also, my lord, on that night, accused was also present with the victim, my lord, on that night. And regarding that aspect, my lord, there are other materials, and from the PM report also, my lord, regarding injury and other marks, I will point out to your lordship. And from that, my lord, otherwise there is no direct material that he is involved in commission of the, my lord, involved in, my lord. Otherwise, cause of death is not yet ascertained. Section registered under section 103. Till now, it is difficult to say, my lord, whether without getting any report regarding exact cause of death.
57 days, my lord.
Otherwise, he
Whole thing is, my lord, because in fact, one of the proposal of marriage was there, but she is minor. So the guardians of both the parties, my lord. So ultimately, petition also refused. Thereafter, something happened, my lord. That is the only case, my lord. So directly, my lord, your lordship, I am not on that, my lord, 57 days, and there is no direct involvement, direct materials against him, my lord. Further custody, because FSR reported, it will take time, my lord.
Do you want to say there is no direct implication?
Yes, my lord. Well, our friend also said, but that not point in that way, my lord. So further custody at this stage, my lord, because FSR reported it will take time, my lord. Already 57 days, my lord. So I think your lordship may consider on the face of that here. So far, other item is concerned, they are all the relatives, AB, that is anticipated bail. Next item, my lord.
Yes, Botakur, he is basically on 57.
That is regarding mark of legacy, my lord, from the PM report, my lord. And statement of an injury mark is also there, my lord. Yes.
Yeah, we can. Correct, Mandari. Correct, Mandari. Okay. Correct, Mandari. Oh. Mandari.
statement of accused is also.
In blood, you have submitted blood, there is no
Yes,
traces of or
there is
anything
no,
was.
yes, ethyl alcohol. So she has not taken any poisonous substance. So it cannot be said to be a case of suicide by way of taking poison.
The accused otherwise denied.
Denied.
Now the question is that for the other family members, whether he was staying with the other family members also.
But from that, my lord, regarding that aspect, my lord, because there is no witness, because immediately after 2 days, my lord, that incident happened, my lord, in the residence of the, whether she consumed poison or not, that is clear from the FSL report. Otherwise, my lord, there is
Here
no
it's
such.
seen this mark of ligature is on the neck part is there.
Yes.
But it is not described whether the non of the
So it is
non
difficult to ascertain.
that is silent.
Yes.
Whether it is a suicidal hanging or
Yes.
antemortem hanging or any other strangulation was there, it's not there. That is anyway, we'll go through it. record. And is there any submission from Mr. You want to
Now,
submit?
from the PM report, my lord, cause of death not yet conclusive, and she has not consumed poison from the FSL report. And
It may not be a case of
and there is no such, my lord, statement of the witnesses also not there, because immediately after 2 days, my lord, in the residence of the accused, she committed the incident happened there, my lord. So regarding that aspect, whether any physical, mental torture, my lord, regarding that aspect, there is no witnesses. Now,
Uncertain, my lord.
now he is a strong suspect, because on that night he was present along with the victim. My lord.
Yes. So your submission, the 57 days is it?
Yes, there's one suspicion only, my lord, because nothing at all, my lord. Further custody, only among that, my lord. Enough, my lord, thoroughly interrogated.
And regarding other
Others, they are not at all, my lord. They family members, your lord's kindly see, my lord. His father, his mother, his brothers and sisters, all family members. Item 19 is the main person against whom there is allegation, my lord. And so far other, your lordship, they are petition number 1 and 2 are parents of accused number 1. Accused number 1 is item 19. Arrested.
their parents.
Parents. And 3 to 6 are own brothers, my lord. 7 and 8 own sisters of accused number 1. All family members. They are named in there.
No, in the FIR, their names are there, no?
Yes, their names are there. This is allegation against number 1. Sister are married, they live separately, my lord, far away, 5 kilometers away.
Okay. for a second. I'll keep it.
Yes.
I'll return you back this day
Yes.
today. Okay, I'll pass you. Apa yang itu? Yes, Bora, you have on one case.
21.
20?
21, next item.
21.
Yes, madam. Case diary was called for, my lord.
21, my lord, as per my instructions, search sheet submitted, my lord.
In this case, my lord, I'm already 68 days, my lord, regarding that SIM card issue, my lord. That whenever the customer comes to me, my lord, I used to issue, my lord, 2 SIM cards instead of 1, my lord. Then what happened, my lord? Out of that 1 SIM card, my lord, one Mr. Mustafa Ali, he has used that particular SIM card for extortion purpose, my lord.
Yes.
Then Mustafa was arrested in a different
But
case.
the question is that that is yours. I have already,
Yes.
I can remember the submission was there for me. But if charge sheet is failed, either we can do one thing, you can approach the trial court below, or we may call for the case record.
Yes, ma'am, because 48, 47 compliance and that also been challenged by us in this particular petition. So a short date maybe with a direction to the registry.
In a stage, short date, we don't have this week, we don't have any date.
Well, it's a case of 48, my lord. There's a non-compliance of 48.
But this week we have some problem. Today also I'm having a meeting by 4:15. I have to rise. This week because of this inauguration of Arunachal.
I can understand that, my lord. But it's a question of liberty of 48.
Yeah,
my lord.
obviously,
That's-
obviously. But do you think that within 2-3 days it will reach? I don't think so. So let it be on immediately on 11th or maybe on 12th. We may try at best. Part Mr. A.M. Bora, the learned senior advocate, assisted by your
V.A. Chaudhary.
Mr. V.A. Chaudhary, the counsel for
Yeah,
evaluation, also by Mr. B. Bottom. It is submitted by Mr. Bottom. That case has already been charged by CS number
CS number 158/25,
158/25,
dated 27/25.
27.
25. Well, this may be kept as a part of the record.
The report of the IO may be treated as a part of the record. Further considering the submission made by learned senior advocate Mr. Bora, let the scan copy of the PCR along with the case diary be called for. At best we can fix out either 11 or 12.
11,
that
madam.
part. 11. 11. You're listing it on 11, let's.
My lord. The registry will take.
Yes, sorry. Registry will take steps.
My lord, I have received the instruction, my lord, charge sheet submitted, my lord. What the cases?
Go the matters.
My lord. File charge sheet number 110/25, dated 31/7.
110.
My lord. 30, no? 25.
31/7.
7, my lord.
So approach before the
CGM.
learned trial court below
Yes.
with an appropriate application. Otherwise, how in item number 13 you are in how many days? 57 days.
Your lordship, 57,
In item number 13. And in item number 14,
54.
54. We'll mention this one. Item number 13 he is in custody, 57 days, and item number 14, 51 days. We're just mentioning your period of custody.
Your lordship. Developed.
My lord, in this case also I have received the information, my lord, charge sheet submitted.
My lord, when that is the issue, my lord, because I was arrested on 5th of June. So 61 days today, my lord. The charge sheet, my lord, till
I
now
don't
it
know,
is
Charge sheet submitted, my lord, that is 2/8, my lord.
2/8.
My lord.
It is not there in the court itself, my lord.
No, no.
We have confirmed, my lord. It is not there in the court.
On 2/8 it was not ended.
Even
you have
today, it
filed-
is not there in the
Yes,
court. Even today, it is not there in the court. My the instructing counsel from Tinsukia, he has confirmed even today it is not in the court.
Yes.
That so in that case we have to call for the entire case record.
My lord.
Otherwise, we are not in a position to, even if it was some submitting may be true.
My lord.
But as per information,
Information,
we got the information from the IO only.
My lord.
The charge sheet has already been
My-
filed. It may not be laid before the
My
consultant
lord.
or may not be laid
My-
before the CTM also.
My
That I don't know.
My lord.
If it
My-
is not,
could the
then
report-
definitely default bill
Yes,
will the question of default bill.
my lord, that
Default.
will come, my lord, if it is not.
Yes.
Come if it is not. So,
My lord.
in that case,
Tomorrow
we
or
have-
day after, my lord, if the report could be called for online, my lord.
This week we are not at all listing any
No, I
report.
will.
In exchange, what kind of report?
My lord, when it was submitted.
No, that will reflect in the order sheet or in the case
Yes.
record itself.
Yes, my lord.
We are not calling any report from the court.
My lord.
We are calling for the entire case.
Case record, my
It
lord.
will
My
definitely, it will be
My lord,
reflected in
my
the court
my lord. my-
when it was put up, when
My
it.
my lord, my lord, my lord. The scanned copy, my.
Yes, sir, obviously. Part Mr. P.D. Nayan, connect counsel for the petition. Counsel for Mr. P. Sharma, the learned petitioner, It is submitted by Mr. Sharma. Yes,
Telephonic
it will
instruction. Telephonic instruction.
On tele.
submitted that through from telephonic. Has informed that his charge sheet has already been filed in the present case. Filed,
I charge sheet number 41 of 25, dated 2/8/25.
In that context, Mr. Nayak, the learned counsel for the petitioner, submitted that as per his information, the charge sheet was not laid before the CTM, even on 2/8/2020, and the petition is in custody for last 61 days. In view of this, the scanned copy of it is here being called.
Forward for piece of case. I will put license at all.
List, yes, when it can be listed.
Scanned copy.
And after 15, my lord.
My lord, already 61 days over, my lord. Today is the 61st day. Within this week, my lord.
This week? We're not.
Oh, okay.
No.
Honestly,
At least
I'll
13
go with
or say 18.
Fine.
18?
18.
This
যদি নহয় তেতিয়াহ'লে তাতো ৰেকৰ্ড থাকিবই or could we attempt before the court below because otherwise could we attempt before the court below before the trial court because 18th my lord she'll be unnecessarily in custody after beyond the period of 60 days.
In that case, we are going to dispose of it.
My lord, could an observation be made, my lord, that the trial court would check the date and the
No,
obviously, one day
I have made the observation, your submission that
Ma'am.
till 2/8/2024,
Yes, ma'am.
fine.
Ma'am.
The CD was not laid before this, so that
Ma'am.
observation I have already made.
My lord, my lord.
So, in view of submission of the charge, petition is hereby directed to appear before the learned trial court with written particular application for which will be considered. Okay.
My lord.
That observation I have already made.
My lord, my lord. Deeply obliged.
Item number
20.
22.
22. My lord, in this
22,
case, my
what
lord,
is the
before
position?
going to the internal affair, my lord, I would like to place
You have
the,
received the case date?
yes, case they received. ma'am. I would like to place the background of the case, my lord. The petitioner number 1, Kusum Borua, she is a, my lord, owner and patadar of 2 kotha 11 lesser land. We have annexed the Jamabondi, my lord. Your lordship may peruse page 20, my lord. Here, her name is reflected in serial number 32, my lord. On the right side, my lord, notice here as saw. Here, my lord, house is there where she is living with her husband. She was living with her husband, my lord, and some rented rooms are also there. And in the year 2015, my lord, she engaged the present informant, my lord, Tutumani Das, as housemaid in the house, my lord. And subsequently, my lord, some extramarital relationship was developed between my lord, husband of the petitioner number 1 and Tutumani Das, my lord. And ultimately, due to the torture caused upon her, my lord, she has to let the house, my lord. And she filed one complaint case, my lord, before the SGM Bozali, my lord.
This Kusum Borua.
Kusum Borua. That was a DV case, my lord. And in the DV case, my lord, the Tutumoni Das, she submitted WS, my lord, written statement. And your lordship may kindly peruse page 28. In paragraph 6, she admitted that she was a housemaid, my lord. Her plea was that since she was a housemaid, my lord, she was not attracted, she was not in a domestic relationship with the my lord. Present petitioner number 1, my lord. That is reflected in page 28, paragraph 6. My lord. And thereafter, my lord, the SGGM Bozali, my lord, disposed of the case, my lord, and protection order has been, my lord, issued. So, lordship may kindly see page
Protection order was issued in favor of petitioner number 1.
petitioner number 1, my lord. In page 41, my lord, in first paragraph, it is stated that on perusal of written statement filed by the respondents, it appears that the fact that the exit is the wife of respondent number 1 is admitted. The fact of marriage as well as living in shared household is not denied at the point of time by respondent. Thus, it is clear that the aggrieved and the respondent shared a domestic relationship as well as a shared household. And ultimately, in page 42, my lord, order has been passed. There is protection order, accommodation order, and maintenance order against the respondents, my lord. Thereafter, she was accommodated, my lord, in the house, and she was residing there, my lord. But in the year 2024, my lord, husband died. That is on 11/5/2024, my lord. And thereafter, again, dispute has been cropped up, my lord, and the Tutumoni Das violated the protection order. And then she filed again a complaint case, my lord, CR 53 of 2024 for violation of the protection order. And in that case, my lord, a spot verification report was called for from the protection officer, my lord. That is at page 45, my lord. May I read, my lord? It is relevant to the case, my lord. With reference to the subject cited above, the undersigned would like to state that the notice issued by Court of Subdivisional Judicial Magistrate Bozali regarding submission of inquiry report of spot verification has been received by office of the undersigned in connection with CR case number 53 of 2024, Kusum Burwa, complainant versus Tutumoni Das and others accused. The following points that were noted are as follows. Kusum Burwa, who is legally the owner of the said property, is unable to reside in her own house, as Tutumoni, maid servant, is creating many inconveniences, such as threatening, shouting, and scapegoating as such. C. Tutumoni is claiming that she was married to Dhananjay Burwa, but on investigating, it has come to notice that she was just a maid servant and no such legal records of marriage has been found. Kusum Burwa is not even getting the house rents and as well as shop rents of her own property, as Tutumoni is claiming the rents. Tutumoni claims to have a child, Dhananjay Burwa, but Kusum Burwa claims that child to be illegitimate, as according to her, Dhananjay was infertile. We have no child, my lord. And my lord, finally, an order has been passed on 20 November 2025 by the SDGM, my lord. And you will also may kindly see page 47, my lord. Here, see, it is ordered that, hence I deem it fit to direct the protection officer to accommodate shelter to the aggrieved party immediately in her shared household as directed by judgment and order dated 10/1/18 in connection with CR number 122/15. The protection officer shall do the needful and may take the help of local police station while doing the same. Now, my lord, your lordship may kindly say the execution order, my lord. That is at page 44, my lord.
Okay, then this is the case. Now, what is the allegation against
Now,
you
my
now
lord,
at present?
Without going in, I would just like to point out to your lordship. My lord, here, out of 15 accused persons, my lord, 13 female, only 2 male accused, my lord. Out of 15, my lord, only, my lord, 13 female, all are female accused, and only 2 is male, my lord. And here, my lord, from the contents of the, I would just like to point out one of the statement of the accused. মোৰ ঘৰ সৰভোগত মই মনুমতী মহিলা সমিতিৰ সদস্য হওঁ, এটি ষ্টেটমেণ্ট অফ ওৱান। মালতী বৈশ্য সভাপতি আৰু ইন্দুনাথ ছেক্ৰেটেৰীৰ কথা মতে যোৱা 23/6/25 তাৰিখে বাগমাৰাত আহিছিলো কিন্তু টুটুমণি দাস বৰুৱাৰ দোকানত that is informant মাইলত অলপ হুলস্থুল হোৱাত মই ঘটনাস্থলীৰ পৰা পলায়ন কৰিবলৈ চেষ্টা কৰোঁতে ৰাইজে আমাক আটক কৰি পুলিচক খবৰ দিয়ে আমাক কুসুম বৰুৱা বাণীকান্ত কলিতা দেৱকান্ত কলিতা পদুমণি কাকতি কিৰণ ডেকাই মাতি আনিছিল আৰু আমাক 60,000 টকা দিয়া কথা আছিল for 60,000 আনিছিল আৰু এজনী মহিলাক তাইৰ ঘৰৰ পৰা উচ্ছেদ কৰাৰ দায়িত্ব দিছিল So, there are 2 injury report my lord.
My lord, here,
So ultimately,
My
case
lord, one
registered
is
under-
housemate.
Case
He raised to the status of the my lord wife of the deceased husband, and one is legally married wife.
That is the main issue.
Yes.
my lord,
Now, this section case is registered.
Materials is there against the accused person.
My lord,
Case registered under which section?
Under
section 61, 191 to 117, 109, 74, 308
117
subsection.
is okay, but 107, 109, is there any? in case?
My lord, but FIR does not reflect.
My lord, one my lord victim is 8 years. My lord, age of the
That is
simple
the
injury.
daughter of Tutumani.
Yes, one my lord. Jutumoni Das Borua. Injury is simple injury. Simple injury, my lord, by bare hands. One Gitasri Borua, 8 years, one victim. Gitasri Borua, 8 years. And regarding that, who caused injury? One by one, from the statement of the witnesses, one Podumuni, my lord, Kapoti, Podumuni ki ase? Podumuni Kapoti. She injured the minor victim, my lord, Podumuni Kapoti. She is petitioner number 2 in item number 31.
2 items are there. Now here these 3 petitioners are in custody since 3/7.
Yes,
Yes,
my
please,
lord, 33 days.
23
So this the dispute basically arose between the one legally married and one the other.
Yes. There are many other things earlier when a dispute is going on.
Since the year 2015.
After death of the deceased husband also it increases when they have a title suit and many other cases and tried to dispossess, protection order, DV Act, everything is there, long history. Otherwise, in this case, my lord, from the allegations, my lord, 2 injury report and these accused persons went there to evict the informant and during that process also injured the minor victim, or that is simple injury of 8 years. And main allegation is again Podumuni Kapoti. He caused injury to the minor victim.
right,
And
right.
regarding other allegation, again all the person, the public caught red-handed, all these accused persons they are handed over to police.
So one Mohila committee was there.
Yes, well, by taking an amount of rupees 60,000, they are actually, my
Oh,
lord,
they took money, 60,000.
yes, my lord. That is the statement of the accused person.
My lord, petitioner number.
Live streaming. Good morning. Live streaming to বন্ধ হয়ে গেছে।
2 and 3 are the sister and brother of the petitioner number 1. My lord. My lord, the local owner is behind the bar since my lord 3rd July, my lord. And the allegation, something is there, my lord, but it is concocted, my lord.
So we are on 22. This is 22.
Yes, 22.
22.
Active number 20.
22 and 31.
LC to UK Das, hard Mr. UK Das, and also hard Mr. Report. Done it. It is submitted by Mr. Das. The copy for the petition. The petition number 1 is the legally married, was the legally married wife of one Hanunjoy Borua, and she is also was the owner of the land and house where she was residing along with her husband. Subsequent, the informant claimed himself to be the one wife, claimed himself to be the wife of the deceased Ranjapur, and thereafter there was some dispute arose, and in that regard, DBA proceeding was also initiated by the present channel. The petitioner, all the petitioners and did not have not committed any such offense as alleged in the FIR. However, it is a fact that there was a dispute between the petitioner number 1 and the informant, who also claimed to be her to be as the wife of the deceased, though she was a maidservant to, though she was working as a maidservant. All the petitioners were are in custody since P7, and hence, considering their rank detention, they will be released. However, they will extend their cooperation in further investigations if they are granted petition privilege. Next, Mr. Water did an investigation that a dispute of the quarrel took place when the present petitioner, along with 14 other persons, including 12 female members and 2 male members, came to evict the informant, and in that process, they also assaulted the informant along with her and minor children. However, he submitted that as per the medical report, the injuries sustained by the victims are minor in nature, considering the entire submission made by them, and also considering the medical is diary. And besides the medical report of the find that part of the investigation may not be required for the presentation. Where this case is? Bojali.
Yes,
Bodhali,
yes,
sir.
Bodhali.
SDGM Bodhali, madam.
SDGM Bojali. MS Nikki. But Bojali now district judge is also there.
Dear madam.
Yes.
So Bojali SDGM
SD
S. Sadar.
Sadar.
31.
31 is AB, my lord.
AB, my lord. Out of same case there, my lord.
Same.
Here one Podumi is there.
Yes.
Podumi, specific allegation against Podumi is that we got. But I will leave
She
it to you.
inflicted injury on her minor. There are 4 petitions are here.
4 petitions.
Submit that they are innocent and they have committed any such offense as a in the FIR. However, the fact that there was a dispute between the 2 wives, that is the informant and one of the co-accused, Kusum Kusumbur. But these petitioners are no way involved in the alleged offense. It happened usually before by the DB actor and the normal case. It is one between the co-accused and the Swans. Our water submission same dispute for the eviction. However, he submitted that the petition number 2, namely Pudubi Korida, had allegedly assaulted the 8 years minor daughter of the informant, causing injury on her person. jury on her person, and the other accused petitioners are also involved in the said quarrel when they try to evict the informant, from the house where she was staying. Okay, you'll be under in previous year's bail prayer is allowed. There will be some conditions, abide by all the conditions. For the petitions, other one is allowed, bail is allowed, and this petition is also allowed. You are granted with privilege of prayers.
May I please, Your Lordship? Lordship, this is a regular bail application. Page 13 is the FIR. May I read, my lord?
Page 13.
I have the honor to inform you that on 26/6/25, based on the FIR submitted by the complainant Hajrat Ali, a case was registered at Abhayapuri Police Station, Bhait, Abhayapuri PS case number 140/25 under section 108/3 within bracket 5 BNS. In this regard, the officer in charge of the station assigned me the case for investigation of the same. During the investigation, I arrested and forwarded the FIR name accused person Quddus Ali, son of so-and-so, village so-and-so, PS Abhayapuri district, Moigaon, Assam, and has been already forwarded to the Honorable Court Notsalmara, Abhayapuri. During the courses of this investigation, on 14 July 25, I got to learn that the two individuals mentioned below demanded a total amount of ₹4 lakhs from the other two FIR name accused of the aforesaid case, namely Soli Sheikh, son of so-and-so, village so-and-so, PSN district, Moigaon, using my name. Sorry. Soli Sheikh, and another is Dilbar Ali, son of Kasim Ali, village Fulkamari, PSN district, Moigaon, Assam, using my name and the name of the Honorable SSP Moigaon for the purpose of exculpating their names from the case, and if the money is not paid, then they would be arrested and forwarded. Subsequently, I inquired the matter and confirmed that the matter to be true and have collected an audio recording in which a demand for money was made using our names. Hence, the below mentioned two accused persons are involved in criminal conspiracy in order to extort illegal money from their personal gain. Now, my lord, that FIR against whom allegation was alleged against me that I have demanded money from that accused, that FIR I have annexed with my petition, that is page 22, my lord. Kindly, page 22, my lord, Assamese vernacular. Here is three accused, my lord. One is Quddus Ali, another Soli Sheikh, and accused number 3, this is important, my lord. Dilbar Ali, Pita Kasem Ali, Sang Fulkamari, Thana O Jila, Moigaon, Assam. My lord, accused number 3, Dilbar Ali. Now, my lord, again, page number 13, my present FIR. Kindly see the accused number 1, Lokman Hussain, alias Bablu, 20 years, son of Dilbar Ali, village Fulkamari, PSN district, Moigaon. Now, my lord, I want to submit here, my lord. Against me, allegation is that I have demanded money from my father in order to remove his name from a case in the name of police. That is, my lord, not believable and trustworthy, my lord. On the other hand, my lord, if we go through the contents of the FIR, my lord, here is mentioned that my lord, he has the present informant got information that two persons extorted money from the accused of that case in order to, my lord, remove their name from the case. Now, after getting the information, my lord, present informant himself inquired the matter. And he, in the contents of the FIR, stated that I myself inquired the matter and got audio recording, which is, my lord, clear violation of the criminal jurisprudence, my lord, because informant cannot be inquired matter. It should be inquired by the investigation officer, my lord, which is clearly transparent with the, my lord, impartial investigation or like that, my lord. So I want to submit in this case, my lord,
On the other hand, my lord, Ezahar was lost by the police. But in this case, victim is that 2% actually from whom demand was made. But that person has not lost this FIR. The lost by the police himself. So, my lord, on the last point I would like to highlight here, my lord. As on today, petitioners are behind the bar 20 days, my lord. So, my lord, at this stage, my lord, a further custodial interrogation of this case may not be required, my lord, because in this case, nothing is to be required, recovered from the custody of the accused, my lord. Already they are since 20 days behind the bar. And allegation specifically against the son of a father, my lord. This is not trustworthy and believable, my lord.
Son of a father.
Yes, my lord, that accused Dilbar Hussain, our present petitioner, son of Dilbar Hussain. Allegation against me, I have demanded money from my father in order to remove his name from a case. This is not believable, my lord. Page 22, my lord, that FIR. Kindly see Dilbar Ali, Peter so-and-so, Besang Pulkamari. And he is my father, my lord. And moreover, present affidavit also shown by him, my lord.
You are Lokman.
Lokman, yes, my lord. Lokman Hussain. As on today, my lord, 20 days, my lord, case was registered under section, my lord, 308/318 BNSS, which deals with the, my lord, criminal, cheating and, my lord, extortion, my lord. Maximum punishment 7 years, my lord. And not, my lord, a direct allegation against me, my lord. Just on the basis of some phone recording, my lord. Allegation is raised, my lord. And more particularly, my lord, in this case, inquired by the informant himself, which is not permissible in the eye of law, my lord.
Who inquired?
My lord, I kindly go through the again contents of the FIR, my lord. Informant himself inquired the matter, my lord. My lord, in between, I got to learn that the two individuals mentioned below demanded total amount of rupees 4 lakhs from the other two FIR accused of the aforesaid case, namely Soli Sheikh, son of Hektullah Sheikh, village Dhontola, Noyapara, PS, Obhayapuri district, Boyagaon, and Dilbar Ali, son of Kasem Ali, village Fulkamari, PS and district, Boyagaon, using my name and the name of the SSP of the Boyagaon for the purpose of exculpating their names from the case. And if the money is not paid, then they would be arrested and forwarded. Subsequently, my lord, this line is important. I inquired the matter. Subsequently, I inquired the matter and confirmed that the matter to be true and have the collected an audio recording. This is not permissible in the eye of law. Informant cannot, my lord, he investigated the incident, my lord.
Yes, my lord, here informant is my lord Nibzuti Nath and my lord IO is one Rose Basumutari, my lord. From record, my lord.
That is admitted.
And
name of
regarding
IO is another, my lord.
So informant is my lord Nibzuti Nath and investigating officer is Rose Basumutari. So informant and my lord IO is not the same person. And regarding why police has lost this FIR, my lord, because they are involving in my lord defaming police personnel in the name of IO and SP, my lord. They demanded money, an amount of rupees 4 lakh, and from the statement of the one of the accused, my lord, Kasem Ali, your lordship, from his statement, statement one, Lukman Hussain, your lordship, they already, my lord, received an amount of rupees 2 lakhs.
From,
specifically in his statement,
from whom?
From my lord, from Hasem Ali.
Hasem Ali is the accused of this case, yes. Accused number 2.
No, from Dilbar from the two victimized person, one already arrested, my lord, regarding from two other accused person. Soli Sheikh and one, my lord, Dilbar Ali.
Dilbar Ali is the father of the Lukman Ali.
And my lord, whether Dilbar Ali is the father of Lukman Ali or not, whether maybe, my lord, one and the same person, whether that needs clarification, my lord. Whether
address is same, my lord, and
address may be same, my name may also be same, my lord.
Present
Then
petitioner
it's-
affidavit, kindly go through the page 10, my lord. Affidavit is
maybe-
shown by the Dilbarali himself.
There are materials against these accused person.
At this stage, my
In
lord,
the
20 days.
earlier also they are involved in my lord, there are note in that regard, my lord. That earlier also these accused persons are involved in demanding money from common men in various police cases, which have promised to settle the case. That is the note of the
Various cases, but case number probably
investigating
not
officer,
mentioned.
my lord.
That is a statement, my lord, but in respect of which case he was demanded, that is not so.
Here in this case, so far I can understand. You can know that this petitioner, along with one Hasem Ali, they, in the name of settling the matter or to
Yes.
stop the case,
Yes, yes.
they demanded money in the name of police.
Police. IONSP.
IONS.
Hasem Ali is the
And in that
accused number
regard,
2.
one audio record clip is also there. Police. And regarding that audio clip 63 certificate is also annexed in the page.
They are forwarded on 16/7/25, 20 days as I put them, my lord. I am the, my lord, son of one accused. Petitioner is, my lord, son of one accused, my lord, against whom, my lord.
Son of one.
Petitioner is son of the one of the accused, but one other accused is also there.
Right. Allegation is that I have taken money, demanded money to remove the name of some accused from that case, my lord. But accused of that case is my father. So I can, how can I make a demand from my own father? It is, I am submitting.
No, your father is an accused.
Accused.
Ah.
And allegation against me, I have demanded money from my father to remove his name.
Whose name?
My father's name from the from that case, my lord. That is the allegation, my lord, against me. Page 22, kindly come again, my lord. My father's accused number 3 is my father. 22. I am denying this allegation. I have never demanded any money from my father or other accused, my lord.
No, in the earlier case, your father got arrested.
No. Earlier, page 22, earlier case, Kuddus Ali was arrested, who is the main accused. This case relating to the abetment of suicide, my lord. Kuddus Ali was the victim's husband. He was the main accused. He was arrested. Subsequent, Dilbar Ali, he was the actually, my lord, like in the Assamese language, Ghotok. Some middle person in between the
Your father.
my father was that marriage, my lord. So due to some arises dispute among their matrimonial life, this victim committed suicide. An allegation of abetment of suicide against the Said Kuddus Ali. And in that case, my father's also made accused. And now allegation against me in the present case, I have demanded money from my father and other accused to remove their name from that case. That is my case, my lord. So I am trying to submit, my lord. I have never demanded such money, my lord. And as on today, I am behind the bar 20 days. My lord, consider the length of detention also, my lord. At this stage, I may be allowed to go on bail, my lord. Because in this case, there is need not to recover anything from my possession further now.
The 2 lakhs from whom they recovered?
From
Who
one.
received 2 lakhs?
Yes. From my lord, Soli Sheikh and there is 2 accused persons, Soli Sheikh and Dilbar Ali from
Dilbar Ali.
That is their case only.
Yes, one of the accused, my lord, Hasem Ali. Hasem Ali's statement is Hasem Ali
As
along with
per
the
the case, it should be, I mean, recovered from these 2 accused, namely this Lokman, the present petitioner, and one Hasem Ali. But the money was recovered from whom?
The money not yet regarding recovery, there is nothing in the case there. The accused stated that গতিকে মই আৰু লুকমান হুছেইনে, the present accused is লুকমান হুছেইন, IC বৈতামাৰী আৰু SP বঙাইগাঁৱক 4 লাখ টকা দি উক্ত কেছৰ পৰা তেওঁলোকৰ নাম নোহোৱা কৰিম বুলি উক্ত পদকীয়া দুজনৰ পৰিয়ালক 4 লাখ টকা দাবী কৰাটো সঁচা আৰু যোৱাকালি তেওঁলোকৰ পৰিয়ালে 2 লাখ টকা আমাক দিয়ে. So this is the statement of Hasem Ali, one of the accused in this case.
Hasem Ali's statement, this statement recorded by
whose পৰিয়ালে দিয়ে?
আৰু পাছত আমাৰ নামত কোনো লোকে থানাত কমপ্লেইন দিয়া বুলি শুনি আমি আজি ৰাতিপুৱা টকাটো ঘূৰাই দিলো.
There is also a written.
No, no, who's কাৰ পৰিয়ালে দিয়ে? Is this there?
Not specifically mentioned, উক্ত কেছৰ পৰা তেওঁলোকৰ নাম স্পেচিফিকেলি মই এজন ব্যৱসায় অভয় পিঠা বিলবুৰ আলী নামৰ জড়িত আছে পৰিয়ালে দিয়ে বুলি only because her family members has provided that amount, well, that is only.
Because why I'm asking, there are two accused in that earlier case.
Yes.
One is his father, is claimed to be his father, and other one is other person. So Porial may be two Porial.
Yes,
That will be
yes.
there. The family will be two families.
Two families,
So from whom it is not
specifically mentioned.
Already recovered also statement there.
Because if one of the accused is his father, then definitely my lord, that other family, my lord, they collected money from that other family. Anyway, I'll leave it to lordship, my lord. Otherwise, the submission of my learned friend that informant is the IO, that is clear that not informant is not the IO. And why police has lost the affair? Because there is allegation against police also.
Police name also involved.
And question of defaming the police
is
for which my lord, an audio clip is also there for which my lord, police has lost this affair.
But probably my lord, statement is also
Consider
there.
that-
There are 2 lakhs already returned, my lord. Kindly consider.
administrator. Yeah, that is done. You, Mr. Azad?
एक किया सर
Take care that parts to be bought. Done it. An application. City receipt. It is submitted by Mr. Azad with the petition. Yes, no. Such office as it is in the app. Further, he submitted that from the present FI itself, it is seen that the earlier case was lost against one against Kutusal and one Dilbar Ali. Dilbar Ali, and said Dilbar Ali is his own father. Thus, it cannot be a case that the name of settlement of the case against them, they will demand against from his own father. Most of the petitioner is in custody since thus when he takes length of detention, he may be released. He will extend his cooperation for the investigation of this case if he is granted privilege. Next, Mr. Submitted that the present there is an involvement of the present petitioner in demand of money. And one audio clip is also recorded by the informant, Further, he submitted that one of the co-accused has also admitted in regards to demand of money from the 2 accused persons who were forwarded in connection with Obhayapuri PS case number 140/2025. Thus, Mr. Bott submitted that there are incriminating materials against the present petitioner, and that apart from the materials available in the case diary, it also reveals that in some earlier occasion, this petitioner also involved in demanding money in the name of settlement of case. Considering the entire submission made by the materials available in the case diary, I find that further custodial interrogation may not be necessary for the present petitioner in the name of for the purpose of investigation. And so go to CGM. Okay.
SDGM North Salmara. North Salmara Obhayapuri.
SDGM M North Salmara. What is the other case number?
24, my lord, same.
Same, my lord. This is
same
case number 2, my lord. Hossein Ali.
Same. No, the father no hoy. He is not the father. Father did was a hard Mr. again লিখিব Mr. Azad Tilan submitted that the self-concocted case has been lost against present petition. He is no way involved. But it is submitted that the as per the FIR, the petitioner along with the co-accused had demanded money for settlement of the case from the two accused persons who were forwarded in forwarded in Homicidal PS case number 140 of 2025. And out of the two accused persons, one of the accused person is the father of the co-accused Lokman Singh. But them Kotakura submitted same receipt for this. Co-accused had admitted that they have taken Kiba. Co-accused now, the accused himself had been side note item number 24. He is not the son of the co-accused or Kibhapane, and the 23 is the son. 22 more dictation, 24 more Kiba. Oh,
Mass of ness. Both are allowed, my lord.
yes.
Mass of ness.
Twenty-six case diary not received.
May I please, Your Honor, brief of the case has been taken back by the client. Client engaged another counsel. Lordship, a direction may be given to the registry. Our name may be deleted. Names are J. Ahmed, A. Hussain, R. Begum, and A. G. Daisy.
J. Ahmed,
J. Ahmed, A. Hussain,
A. Hussain,
R. Begum, and A. G. Daisy. May be
name
deleted.
should be deleted.
A. G. Daisy.
H.G. Daisy.
May be deleted.
Brief has already been taken by the other counsel, engaged other. Mr. Mahmood is appearing here now.
I am appearing, but I have been engaged by my junior M. Ali.
NOC already given. We have submitted
All of
ballot
it is
number.
facility.
Our name is there.
No, but all the names are here.
All the names are earlier set of council. She is telling those
Yes,
name, and
yeah.
now my lord sir's name and my name is appearing. My lord, we are newly.
So you're Mr. M. Ali and Mahmood is also.
Yes.
And what is the case position?
CD not received.
My lord, I have submission. This is anticipatory bail application. Lordship may kindly see FIR, page 19.
No, we are not going to hear. CD was called for.
Yes.
It is not received, na?
Well, the co-accused have been released on bail. In that view, my lord, we expect co-accused they have been released on bail.
They were the anticipatory or
Anticipatory bail, one is granted anticipatory bail, main accused, and another was few days in jail. So that anticipatory bail, Lordship may kindly see, this is Suraj Zaman.
anticipatory bail for one of the co-accused.
He is the main accused. He has been granted anticipatory bail.
But on the first day, you were not provided with any interview. So at that case, we cannot say. You could have praised the.
Sorry, my lord, both are anticipatory bail granted. In both the cases. My lord, case.
So now here only one Rakibul is there.
My lord?
Now your petition is for Rakibul Hussain.
Rakibul Hussain. And Korom Ali and Suraj Zaman.
They were already.
They are already on anticipatory. Both are anticipatory bail. My fact is this, my lord.
No, we are not going to.
But my lord, at least interim protection may be provided.
No.
On 21/8, my lord, I can produce the case.
Because on the first day, the same court had passed the order, this order. So you could have praised the court on the first day of filing for any interim protection also. That was not there. I don't know why. There may be some reason that I don't know, but it was only case diary was called. So you can issue reminder, but it is a fact that if case is fixed for case diary since to
22.
first day it was listed
Interim bail was provided by.
23/5 was the first day. Then when the case diary was initially called for and fixed it on 10/6 and then 20/06 and 3 days has already gone.
In our case, my lord, interim bail in protection was given to one of the main accused, page 90 candidacy of our petition.
No, I can understand, but this was not, I mean, your petitioner was not granted.
My
this
petition
stage, I
was
cannot
not there.
At this stage, I'm not granted.
However, if CD does not come, then on the next day it may be considered.
Right.
That may kindly be observed. Because all the main accused persons have been granted bail.
What else? What is her name? Who just name MS8. Her MS8 to say the learned counsel for the petitioner, and it is submitted by her that she, along with Mr. J. Ahmed, MS R. Begum, and MS S. H. G. Deji were previously engaged counsel, but presently the petitioner has taken back the file and new set of counsel has already been engaged. And thus she prayed for deleting or withdrawal of their names from the cause list. In that regard, the registry will be needful. Next para, Mr. H. Ali. Now, registry will is accordingly hereby directed to delete the name of his counsels from the list of counsel for the petition. That's Mr. M. Ali, the learned counsel appearing for the petitioner, and submitted that he has been newly engaged along with Mr. M.U. Mahmood to in the present case by the petition. Next para, Mr. Portable submitted that the CD not received. Though they have already issued the notice to the I on post. Next para, on basis of the case record, that the IO failed to furnish the case diary in spite of lapse of 3 consecutive days, and accordingly, IO is hereby directed to furnish the case diary on or before the next date of listing. In default, the IO may be served with a personal show of this. Issue reminder accordingly, and the necessary order may be passed in default of furnishing the case diary by list accordingly. You want to fix any date or as soon as the case diary is
The date may be fixed, otherwise it would be difficult for us to call for the case diary.
that case what's
A short date may be fixed.
22, it
list on 20. We'll pass necessary order of it.
27.
Rightly,
So
Your
what is
Lordship,
the
when
position of
CD not
20?
received, my lord,
He also CD not received
not received.
the first date, I think.
Theft of bike man.
Pardon?
Theft of bike man.
Oh,
Theft.
Lordship, the bike already recovered from the prime accused, and he also granted bail by the trial court.
after his arrest, I think.
Yes, Lordship.
Let us peruse the case diary. We cannot say at this stage that your involvement may be there, may not be there. That I
Lordship,
cannot.
because of we have criminal antecedent previous. Last year we arrested along with that other accused.
That may be one of the reasons.
Yes, Lordship. And till the case there come, it is possible to grant the interim bail, Lordship.
No.
Because in this case we are not involved. No way we have involved.
That is your submission. CD not received. Issue reminder. Police, the IO is thereby directed to furnish the case diary on or before the next date of listing. Accordingly on 20, let it be on 26th or 20, otherwise I.
Yes,
23rd is the open day,
no, 23rd, no.
it's a holiday,
Mm.
24.
1st of September
No, maybe on 26th of October,
or 26th. Yes.
list on 26th. Issue it.
File it, please.
29.
Yes, what is the position on
May
29?
please your lordship.
Just a second. CD you have received?
CD received.
Are you on interim earlier?
No, no.
No.
Lordship are
Yes,
not,
Mr.
lordship was impression in granting interim, but lordship on that day, lordship one mistake is there, lordship. That is why I have withdrawn this petition and subsequently filed this petition. Yeah, in this case, lordship, the informant is a 27 years so married lady, lordship, and the mother of the child, lordship.
27-year married lady.
Married lady, lordship, and petitioner also lordship, married person, lordship. Lordship, FIR will find page number 17, lordship, and after 6 days of the alleged occurrence, lordship, and FIR has been lost, lordship. And apparently, lordship, section 387 is there, lordship, but there is no other family members, husband or the other well-wisher, lordship, not lost FIR any. And subsequently, she returned home in the next day, lordship, and lost this FIR, lordship. And for a moment, page number 17 is the original version. May I read, lordship? So a type copy may I read, lordship? Page number 14. And there are 3 numbers of accused here, lordship. With due respect, I beg to state that the accused number 1 is known to me, and for which frequently I used to talk with him over telephone. Last on 26/5/2025 in the evening at about 2:30 p.m., I used to come out from my home and I am going to the Campo Bank. After come out from home, I have met the accused person in 4-wheeler vehicle near the Axia petrol pump, and the accused number 1 asked me where I shall go, and I told the accused persons that I shall go to the Campo Bank. Then the accused person asked me to drop at Campo Bank, for which I get in the car. And but instead of drop me at Campo Bank, they took me to the house of the accused number 2. There, the accused number 1 used to kept me for a night in the house of accused number 2, and threatening accused number 1 by threatening established physical relation with me many times against my will, lordship. And on 27/5/2025, the accused number 1-2 went away after left me at Mornoi, Gwalpara, at the said vehicle. And so, my lord, apparently, lordship, incident took place on lordship 26/5/2025. FIR has been lost 1/6/2025, lordship, after 6 days, lordship. And in between, lordship, there is no any other allegation and lordship. And in a small vehicle, lordship, car. And first he used to come to Palakbari, the accused number 2 house, lordship, at Palakbari. And on that night, lordship, and he used to stay in the house of accused number 2. And next day morning, lordship, again accused number 2 and 1 they brought to her to Gwalpara Mornoi in a vehicle, lordship. But in between this time, lordship, there was no any objection, there is no any human right. Even then the family members or other person, they have not any lost any FIR, anything else, lordship. So the FIR is very much clear, lordship. They are the same locality. They have talked with over telephone frequently. So, my lord, if there is anything happen, lordship, is consensual. Otherwise, the petitioner is a very poor person and he is a driver of a vehicle. And he used to stay in the house of accused number 2. And accused number 1 has established a physical relation with the, and there is the other family members, lordship, and joint family, lordship.
No, your petitioner is accused number 1 or 2?
Lordship, I am 1, lordship.
You are 1.
1, lordship.
So you are the person with whom the girl has talked frequently over the.
Yes. We are same locality, lordship. At Poco area. But otherwise, lordship, the kidnapping part is, lordship, and if she is kidnapping the family member, her husband, and the other in-laws or
She's
other
a married lady.
married woman, lordship, married, and the FIR itself is, lordship, and FIR, lordship, kindly come to, lordship, page number, lordship, 13, the 13 page, lordship. Informant Sri Sumi Rava, wife of Sri Aman Rava, lordship, and a 27 years old lady, lordship. So, my lord, after 6 days, lordship, so, my lord, My humble prayer, Lordship, very poor person, and he's a driver. I have also an driving license also. But he stay in the house of accused number 2, Lordship, and accused number 1 has Lordship relation on this time. So after 6 days.
Yes.
Yes, ma'am. From the 164 statement, it reveals that main allegation is against the present petitioner. ma'am. Allegation of forceful physical relation is against the present. Your lordship will have to move back to the second page, ma'am. Not corrected.
Epoch and keyboard PP appeal. This is an application. It is submitted by Mr. President.
Next to one.
It is submitted by Mr. Pop. The Kalan counsel for reputation that he is innocent, has not committed any sexual offense in the FIR. However, it is the fact that he was known to the victim and they had a friendship and even used to talk about it. But the alleged incident is alleged to have been committed on 26/5/2025, but the FIR is lost only on 1/6/2025, the 5 days of without any explanation in regards to delay in lodging there. The victim is a married lady and if there is any physical relationship was there between the informant victim and the accused petitioner, it may be consensual and there cannot be question of any force, could not be any forcible, and there cannot be any question of forcible physical relationship. However, the petitioner is still ready, willing to cooperate in further investigation of this case if he is granted with privilege of re-entry. Next one, Mr. Waterford, you done it submitted in this report that the CD reveals sufficient document evidence against the present accused petitioner, and the victim also brought the allegation against the present petitioner in her statement recorded under Section 183 BLSS. Mr. Waterford accordingly resolved it and submitted that the custodial information may be independent. Next product hearing submission made by running is that and considering the matters is that statement made by the victim under the case. I find that custodial interrogation may not be necessary in the present case, and accordingly I find that it's to extend the privilege of pre-arrest to okay, you will grant.
Deeply obliged, Lordship. Deeply obliged. Published, Lordship, published.
My lord, here, my lord, CD receive, my lord. Here, my lord, section 8 added, my lord. As per my lord, order dated 18/7, my lord.
It will be listed before appropriate.
Appropriate.
And one thing, my lord, we have not made party, my lord, private respondent.
Then-
Petition.
Pardon?
My lord, private respondent informant, my lord, we could not
Informant,
make
yeah,
party,
no,
my lord.
Anything.
Well,
you
then
have to
earlier
take
it-
before the appropriate bench.
Appropriate. then.
Part Mr. J. U. M. Lashkar, and M. Lashkar, they done it constitutory petition. Also part Mr. P. Sharma, they done it. So it is submitted by Mr. Sharma that CD receipt for comparison of same. It is seen that section 8 also has been added during the in view of it. Let the matter be listed before the appropriate bench. And let you retain the case diary so that
Yes,
can
my lord.
oh otherwise no you have
My lord.
made party also. This
My
will
lord.
be list before the appropriate
My
bench.
lord, date may be fixed, my lord. Otherwise, it will take time.
They will have to amend, my lord. Or file affidavit, my lord. Also, that may be also.
And before the appropriate bench, it will be
My lord.
or in the meantime you
My-
can also file
my-
an before appropriate bench for 13 before appropriate bench 13
ঠিক আছে।
It's in the city. It's in schedule, it's in.
CD কি করব CD written let us see CD written till next date if it is there and then now CD written till next okay.
Oh, I'm ready.
This year.
I still has very big.
My lord, before starting my senior counsel, my lord, here I have gone through the record, my lord. In the record, only FIR copy is there. Lord, may kindly page last.
Only FIR.
Only.
What?
Only 3-4 pages is there, my lord.
Sorry? Is there any stay? Stay was there any?
So far, my knowledge.
No, my lord. I have verified, my lord. In the last occasion, my lord, Lordship was pleased to add the line, my lord, interim order passed earlier said continue. But I have verified, my lord, I have not found any order, my lord, regarding the interim or stay, my lord.
That is one of we also did a mistake in that regard because
Yeah,
someone appears
My
and
lord.
tell us that interim was there.
There, my lord.
So we did a good faith actually interim was be continued.
Lordship, may kindly
it
page
might be
the
so
order
much.
that
That
is
should not
31.
be the submission from the council.
My lord, 31
Yes.
10, my lord, 2013, my lord.
This is the first order.
First order, my lord.
It may be
No
so.
such interim was there.
No, my lord.
My lord, it may be so, but
My
no.
lord, if interim
should
is not there, my lord, then we will have to take instruction, my lord. Whether case is, my lord, it is charged or any other.
Yes,
What is
my-
happening,
let
my
them
lord?
take.
Then suppose if otherwise it is the
Ma'am.
interim was not there. But the question is that
Record.
at what stage you have filed the petition for quashing?
Quashing of FIR.
Quashing of the FIR.
FIR. At the initial stage when it was registered, and it was registered on 28.
Then why CD was not called for? Why record was called?
Record.
I don't know.
My lord. Because earlier order, my lord, I have seen, my lord.
As per him, why
Record
it
for
was
what?
for the for quashing of FIR only. Then why?
In the order, my lord.
Yes, quashing of FIR only.
My lord, 21 2014, my lord, order dated 20 20
21
1 14, my lord. 14, my lord. In this order, my lord, it was admitted and called for a report, my lord.
And that may be the reason that I
Oh,
did
that
not
may be
pay
the
for
reason.
stay.
Oh,
That may be the reason that I have not paid for stay.
then to enter obviously they will send this one only
My lord,
because
only 3-4
because,
pages, my lord.
because that is there only.
Only FIR is there.
Only FIR is there. And obviously they rightly they have submitted only
My
FIR.
only FIR. Then CD
Which
part
is
is
all for the, and do you have any information by that time whether charge
Nothing,
sheet was filed?
nothing.
No. Charge sheet is filed. No.
I do not know why.
Achha.
2000 meter, my lord, definitely. It will be
2013 meter.
definitely something.
12, more than 12 years.
Okay. Heard Mr. O.P. Bhatt, the counsel for a petition. Also heard Mr. B. Sharma, the petition PP. Submitted by Mr. Sharma that though the LCR receipt, it contains only the copy of the FIR, and that about there is nothing in the case report. On basis of the record, it reveals that the present petition is filed for washing off to the FIR, and thus it is it cannot be said that the state has to whether there was any whether the case was ended with the charge. In view of this, the present petition he done it additional PP submitted that he may inquire the matter as to whether CD charge sheet is filed or not, and in the same time he prayed for call for to pray call for it. In view of this, let this be issued call for the case diary.
My lord, Romia PS, my lord, 410 of 2013. That remains.
Of case diary of Romia PS, case number
410 of 13.
410 of
You may be. Right. 410.
yes 410 of 2013
13.
of Romia PS.
Romia PS.
And GR case number 110013.
Corresponding to GR case number 1100 1100
30.
2000. Corresponding to GR case number 1100. So okay, then let the call for the case diary.
Yes. If there's this, if the police has not taken further action in that case, the matter will come.
But deadline, my lord, interim order is not there.
No, I have not.
Mild.
It was inadvertently,
Mild.
and most probably inadvertent submission from the other side also.
Mild.
Yes.
Mild.
But we should be cautious also. Least after 2 months. You want any date, na?
No.
As a CD.
No, my lord. A CD, my lord, no. I'll take also. My lord, after 2 weeks, my lord, that may be given.
After 2 weeks, we'll list accordingly after 2 weeks. On receipt of, immediately after receipt of the case.
My lord.
Much okay.
Easy. 36, state is there, 36. Okay. You are in 36 also. Yes. So hearing of appeal,
My lord. My lord.
we have received it this year, na?
My lord.
My lord, appeal against 4 years, 6-month conviction. Lordship, the accused was arrested on 7/11/2022, and today is 2 years, 8 months, 28
We are
days.
hearing the entire appeal only.
Only.
Appeal.
But
Because everything is ready, this year with us, we can go for the appeal. He was convicted
he was convicted under section 448 and
448.
And 354 of the IPC, Your Lordship.
Yes, IPC.
Lordship.
IPC.
IPC.
448, 354.
448 and
What is the
350.
term, sir?
Lordship.
448 and 354.
354.
IPC.
IPC.
Term of conviction sentence was? Term of sentence.
One is 6 months and 354 is 4 years, Your Lordship.
Initially,
Lordship, 4 years.
376 was there.
My lord, under section 448 and 354, RI for 4 years and pay fine of rupees 5,000 under section my lord 354. And RI for 6 months under section 440. Mainly 4 years.
Yes. My wasn't.
My lord, may I please, Your Lordship? There is no any eyewitness in this particular case, Your Lordship. And
Eyewitness was not there. No eyewitness.
no eyewitness, Your Lordship. And the complainant, that is the PW1. Her statement is corroborative, Your Lordship. May I read it?
Yes.
Your Lordship, may peruse page 15, Your Lordship.
Of your appeal memo?
Appeal, Your Lordship.
Yes.
It has been seen that the evidence of PW1 is corroborated by her previous statement given before the magistrate in all material particulars of the prosecution case. Being corroborated by her previous statement, the evidence of PW1 becomes consistent and coherent regarding the material particulars of the prosecution case. Such consistent and coherent evidence inspires credence. And Your Lordship, 17, Your Lordship.
So here the court observed that her statement in every stage remain consistent. Consistent state. Yes, then?
Lordship, PW2. That is the mother-in-law. Is the mother-in-law of the victim. Testifies that she came to know about the incident next morning, Your Lordship. And there was a hue and cry in the village. The victim had told her that the accused mounted her bed and attempt to commit a bad act on her. She has denied the suggestion of giving false evidence. And Your Lordship, Lordship, if we come to the deposition.
Yes. In the there.
Yes, ma'am.
You
Yes,
have
sir.
not the next year, na?
Recording of
You have to produce the record.
Yes, Your Lordship.
PW?
PW1, Your Lordship.
Yes.
The complainant herself on oath. I'm the informant and victim of this case. I know the accused. He is my neighbor. The incident took place on 6/11/2022 at about 9 p.m. I was at home along with one of my minor daughters. My husband has gone to attend a marriage ceremony at Goepani. I was watching TV at the time. I fell asleep. I did not bolt the door, Your Lordship. She has said, I did not bolt the door as my husband was to come. The accused entered the house. He pulled out the lights
Then the accused mounted on me. Then I woke up. I slapped the accused. Then I took the accused near his wife. I narrated the incident to the wife of the accused. The wife of the accused also assaulted the accused. Then the accused fled away. I informed my husband about the incident over phone. He came immediately and searched for the accused, but the accused was not found. I narrated the incident to my husband. On the next day, I lodged the Azahar. The Azahar was subscribed as per version. P Exhibit 1 is the Azahar. P Exhibit 1, subclause 1 is my signature. After the institution of the case, police sent me to the hospital for my medical examination. Police also sent me to the court for recording my statement. I gave my statement before the magistrate. White so-and-so are my signature. And in the cross part, your lordship, the accused used to come to our house. He sometimes come to watch TV. There are 3 rooms in our house. The TV is in the first room. The next is our bedroom. On the day of the Elise incident, I was watching TV from the bedroom. TV can be seen from our bedroom. At the time of the Elise incident, my 7-year-old daughter was with me. The light of all rooms were switched on at the time. On the day of the incident, at the time of the incident, I did not bolt the door from inside. I usually close the door of our house at about 8 p.m. But on the day of the incident, I was not closed. It was not closed. I did not wake up when the accused entered our house and switched off the lights of the rooms, including the kitchen. The house of the accused is adjacent to our house. On the other side of my house, there is a house of the elder brother of the accused. On the day of the incident, the accused was wearing a sporting and a half pant. I did not remember the color of his wearing apparel on the day. I raised alarm as I woke up, but nobody came. Police recorded my statement. It is not a fact that I have had not stated before the police that I have slapped the accused. It is not a fact that I had not stated before the police that I took the accused near his wife, and I narrated the incident to wife of the accused. It is not a fact that I had not stated before the police that the wife of the accused also assaulted the accused. It is not a fact that I had not stated before the police that on the day of the Elise incident, the accused entered our house and switched off the lights of all rooms. It is not a fact that I had not stated before the police that the accused mounted on me. It is not a fact that today I have deposed for Lordship. She has stated here that she took the accused to the wife of the accused, your lordship, but the prosecution side has failed to produce the most vital witness. This is the wife of the accused, your lordship. Her statement should have been recorded, your lordship. Your lordship. Lordship may peruse the FIR, your lordship. FIR, your lordship.
Yes.
Lordship, I'm not fluent in Assamese, my learned.
May I read the FIR, Your Honor? সন্মানপূর্বক বিনীত নিবেদন এই যে শ্রীমতী সরিতা তাঁতী স্বামী ৰামধন তাঁতী ৰিচাকমি 2 নম্বৰ লাইনৰ দৰিদ্ৰ পৰিয়ালৰ নিবাসী হয়। বিশেষভাৱে আপোনাক জনাবলগীয়া হয় যে যোৱা 6/11/2022 তাৰিখে নিশা প্ৰায় 9টামান বজাত মই ঘৰত শুই থকা অৱস্থাত ওচৰ চুবুৰীয়া ৰাজেন নাগ পিতা স্বৰ্গীয় আছাম নাগে মোৰ ঘৰৰ জ্বলি থকা লাইটখিনি অফ কৰি মোক ধৰ্ষণ কৰাৰ চেষ্টা চলায়। এই সময়ত সাৰ পাই ধৰ্ষণকাৰীয়ে পলাবলৈ ধৰে তেওঁৰ পিছে পিছে দৌৰি গ'লে ধৰ্ষণকাৰী নিজৰ ঘৰলৈ খেদাই যদিও তেওঁৰ মানুহজনীয়ে ঘটনাটোৰ বিষয়ে অৱগত কৰোঁ তেওঁৰ মানুহজনী ধৰ্ষণকাৰীক 2 লাঠি মাৰে যদিও তেওঁ পলাবলৈ সক্ষম হয় গতিকে মহোদয়ে উক্ত দয়ালৈ দয়া কৰি ধৰ্ষণকাৰীক উপৰোক্ত কঠোৰতম বিহিত ব্যৱস্থা গ্ৰহণ কৰে যেন এই মোৰ আপোনাৰ ওচৰত বলিয়া বিনম্ৰ অনুৰোধ Your Honor, in the context of the FIR, it is not been reflected that she has been opened the door because of her husband was outside and her husband was went to attend for some solemnization of a marriage, Your Honor. But in her statement, it has been reflected that
Yes, she opened the door as her
Yes, Your Honor.
husband was outside.
Yes, Your Honor. And her minor daughter was also with her at that particular time when the incident was took place. Because it is not possible, because her minor daughter and what is the age of her minor daughter, that was also been not mentioned in that particular case, Your Honor. And all the evidences were submitted by the prosecution side, Your Honor. All the evidences were hearsay evidence, Your Honor. No one can be hurt by themselves, Your Lordship.
Yes, that is.
My lord. And she has stated that she was with her minor daughter. That is 7 years old. She should have bolted the door, Your Lordship. That is at night time. Her husband was not at home. He has gone to play drum in a marriage function. He usually play drum, Your Lordship. And the marriage ceremony in Assam, in our ritual, or whole night, the ceremony, it used to be there. So, my statement may be recorded. My lord, and prosecution witness 2, Your Lordship. Deposition. The victim is my daughter-in-law. I know the accused. He is my neighbor. The incident took place about 6 months ago. I took place at about 9 p.m. I was at home at the time. I came to know about the incident in the next morning as there was hue and cry in the village. Then I went to the house of the victim and I asked her about the incident. She told me that the accused has gone up in her bed and attempted to commit bad act on her. The husband of the victim was not at home at the time of the incident. He has gone to a marriage ceremony. It is true that I had not stated before the police that the victim had told me that the accused got up in her bed and tried to commit bad act on her. It is not a fact that that today I have deposed falsely against the accused, as this case was lost by my daughter-in-law. Lordship, PW3.
Yes, speak.
I know the accused. He is my neighbor. I know the victim. The incident took place in November 2022. I was at about it was at about 9 p.m. I heard that when the victim was sleeping at her home, the accused entered her home. The accused also mounted over the bed of the victim. At that time, the husband of the victim was not at home. He had gone to beat drum in a marriage party. The accused had ran away when the victim raised alarm. I do not remember from whom I had heard the incident. The victim is my relative. It is not a fact that today I had deposed falsely that the accused had entered the house of the victim and mounted over her bed. It is not a fact that today I have deposed falsely against the accused, as the victim is my relative.
So these are all hearsay evidence.
Lordship, all hearsay.
PW
And
also said
your Lordship,
husband is being examined.
Lordship,
Husband was examined. Husband.
Lord.
Who is the husband? PW. PW4 is the sister-in-law.
Oh. Yes, ma'am. Her husband.
Not examined.
Examined.
Yes, Rajasthan.
Right.
PW. Name of her husband
Ramadan Tanti.
is not examined.
Lordship, no, Lordship.
Because PW4 is one of the neighbor.
Lordship.
The PW5 is also a neighbor.
Lordship. Neighbor, your Lordship. Lordship, no one came at that particular time. On that is at the night time. That means the incident never happened. That means the incident never happened, your Lordship.
What? What? That means why incident never happened?
Means your Lordship, no one came.
So you see, in the
There was
night
no.
hours, he was sleeping, and the other villagers were also, someone was busy with the marriage function, and some were sleeping. So at that very moment, may not come. But then doesn't mean that incident had not happened. I don't know, but otherwise you can submit.
Lordship, in the medical officer, there is MO.
PW?
DW. No,
Which PW?
he has
PW6
PW6, your Lordship.
Yes.
No external injury was found. There's no any injury. My Lord, deposition of
external? Therefore, you're saying no external injury?
Yes.
Where from? Where from you say?
Lordship.
From his evidence or from the?
That is on oath, your Lordship.
Huh?
On oath.
Acha,
From
no
the
external.
evidence, that is the on oath.
Acha,
He
acha.
has
An
stated.
examination, no external injury was found.
Lordship. Lordship, may I read?
Yes.
Lordship, may I read PW7? That is the IO.
Yes.
On 7/11/2022, I was working as the FS officer at Dumduma PS. On the day of the OC of Dumduma PS received one Azahar from one Sarita Tanti. On the basis of the said Azahar, Dumduma PS case number 341/2022 was registered and the same was endorsed to me for investigation. Prosecution P Exhibit 1 is the said FIR. P Exhibit 1 Subclause 2 is the signature of SI Nil Pavan Kalita, the then OC of Dumduma PS. Along with his endorsement, I recorded the statement of the informant and victim at the PS. I sent the victim for her medical examination. I also sent her to the court for recording her statement under Section 164 CRPC. I visited the place of occurrence and prepared sketch map of P Exhibit 4. Exhibit 4.1 is my signature. I recorded the statement of other witness at the place of occurrence. I arrested the accused and forwarded him to the court. I collected the medical report and a copy of the statement of the victim recorded under section 164 CRPC. On completion of investigation, I submitted charge sheet against the accused, White so and so, Lordship, and in the prospered, Lordship. I took up the charge of investigation on 7/11/2022 at about 3:15 p.m. in the Azahar. The case was registered as Dumduma PS case number 340/2022. In the sketch map, I had not indicated specifically in which room of the house of the informant the incident took place. I did not seize anything from the place of occurrence. I also did not seize the wedding appeal of the victim. Prosecution witness 1 had not stated before me that she had given one slap to the accused. Prosecution witness 1 had not stated before me that she had taken the accused near his wife, and his wife also slapped him. PW1 also had not stated before me that the accused switched off the light in the house. PW1 had stated before me that the accused mounted her bed. She did not stated before me that the accused mounted on her. It is not a fact that I submitted charge sheet in this case without making proper investigation into the case.
So the contradiction were confirmed by the I.
Lordship, this is my humble.
Any other submission?
Lordship, he is the only one member in his family, earning member in his family. They are suffering problems, Your Lordship, financial hardship. Lordship already almost near about 3 years, and the punishment 3 years he is languishing in jail, Your Lordship.
Your judgment is only on
4 years.
judgment
1 year of
12/10/2023.
2 years, 8 months, 28 days. He is languishing in jail till date, Your Lordship.
Almost 3 years.
Almost 3 years.
No. 12/10/2023.
12/10/2010.
23. From the judgment, 12/10/2008, it will be 1 and 9.
He
1 year, 9 months.
submit most probably he was in custody
Then
during
3
the
months.
during
Then
the
if
entire
he-
trial.
3 months, then
trial.
it will be 2 years.
Not 2 years, but he is in. I don't know. He may be in custody during the entire trial.
Yes, he
That's
is was
what
in
he might have submitted.
He was in jail, Your Lordship.
Okay, anyway, stay. Hey, report. Yes.
My lord, I have done to the record, my lord, and judgment also, my lord. From the record, this our submission was that there is no any eyewitness. In such type of offences, my lord, there is no need for any eyewitnesses, my lord. There is no need
Possibility
for
eyewitness. Possibility of the eyewitness may not be.
my lord, my lord, my lord.
No more hearing. Over. You know. Oh. So
My lord,
possibility of eyewitness
not
may
there.
not be.
My lord, my lord. Thereafter, my lordship may kindly, if we will go to the evidence part of the PW1, my lord, victim, my lord. From my statement, my lord, it reveals that on that night, my lord, he entered the room, my lord, and mounted on her, my lord, as per her statement, my lord. And all the witnesses, my lord, corroborated her statement. Although the petitioners had said that they are, my lord, hearing witness, my lord, but on the question asked to the, my lord, victim, my lord, when the question was asked to the victim, my lord, then she informed that that incident was occurred, my lord. And in the judgment also it was discussed, my lord, why they are relevant minor. Their evidence are relevant minor. And regarding the medical documents minor, not necessary minor, perhaps also not any opinion minor in this regard minor. I have not found any opinion minor.
No, obviously,
Not
it was an allegation
minor.
of
No, minor. Only
tried to commit, but there was
not
such
not
other.
minor. And from the statement of the all the minor, it was corroborated. And the court below, after going through the all the details, minor discussion about the evidence of minor, PW 1, 2, 3, 4, 5 is also important minor. That's kindly say the PW 5 minor.
PW 5.
5 minor. He is the neighboring minor. He was informed by the victim minor, and I have played for minor. Kindly say PW 5 minor. Important minor.
Yes. Yes, she was also with her husband when he in.
My lord, that marriage, where the marriage ceremony was going. It was corroborated by the present witnesses also, by the PW 5. Therefore, Lakshmi kindly page 164 statement minor. I have like my mother. Here also she has stated the thing what happened to her mother in 164. Details matter in details she has explained. And 164 and deposition before the court matter, she is very much consistent matter. Very much consistent manner. That incident occurred, how she has taken the accused person to the wife before wife minor. That also mentioned in both the minor statement minor. And she is very much consistent manner in 164 and deposition before the court minor. And another thing is that minor court below, after going through the evidence of all the minor witnesses minor, he was convicted only under section 354 minor. That details also discussed in the judgment minor, why 354 judgment was given under section 354. And my submission that the court below has rightly passed the judgment minor, there is no any inconsistency minor. And after going to the evidence minor, court below has rightly passed the judgment minor. And one important thing is that minor, in such type of offenses minor, victim statement is sufficient minor. There is no necessity for the corroboration if it is trustworthy and believable manner. There are several judgment minor from the Gurmeet Singh to minor from the minor Thul Singh. It was stated that minor victim statement is sufficient in such type of offences, not necessary to corroboration to any other person minor. If it is believable and trustworthy. In the present case also minor, there is no she has stated minor statement and also corroborated by the other also minor, it is believable, there is no any inconsistency minor. And that my submission is that it is not a case for acquittal minor, and victim statement is in her statement she categorically stated his involvement manner, how he is involved manner. It is not a case of acquittal.
My lord, there is also a
Pardon?
There is also an IA for bail, your lordship.
No, we have heard the appeal.
Lordship.
So it will be disposed of accordingly along with the main appeal.
Lordship.
As appeal is all actually ready, that's why we thought that better to hear the appeal. We'll pass here.
No.
Order to call it. Okay, we'll pass the order.
My
Hello.